His Lordship. My Lord, with due consent from the other side, I beg to mention item number 9, my Lord. My Lord, here my senior is out of station. I pray that this matter may be adjourned for the day.
You are for which party?
My Lord, I'm for the petitioner. I stand on behalf of R. Mazumdar.
Have you informed the other side?
My Lord. Yes, my Lord.
Okay, as wait for Miss
T. Wapangla.
T. Wapangla, Learned Counsel, appearing on behalf of Mr. R. Majumdar, Learned Counsel for the petitioner, when not objected to by the other side. Matter stands adjourned for
One day, for a day, my Lord. For a day.
adjourned for the day. All right.
Obliged.
Please, question mention for listing, Lordship.
Go to court number 5.
What of I?
Yes.
Please, your Lordship.
Yes.
Lordship, beg to withdraw this petition with liberty to file afresh.
Why? What is the reason?
Lordship, we need to add some extra documents.
What is your good name?
S.R. Mazar Bhuiya, appearing on behalf of A.M. Bhuiya.
On the prayer made by Miss S.R. Majumdar,
Mazar Bhuiya.
S.R. Majar Bhuiya, appearing on behalf of
A.M.
Mr. A.M. Bhuiya, Learned Counsel for the petitioners. The writ petition stands dismissed as withdrawn. The liberty to file afresh. Yes.
Obliged.
My lord, due to waterlogging, my lord, counsel for the respondent is not able to come here, my lord, in the court today. So, my lord, some time may be granted.
Due to
Due to waterlogging, rainwater logging.
Waterlogging.
Yes.
My lord, last occasion, some document has been submitted upon me, my lord, regarding compliance, non-compliance, my lord. They have stated that in my e-death certificate, my name was written as Parin, Sanas Parin. Actually, my name is Sanas Parvin. My father's name and mother's name are similar. On that account, my appointment has been denied.
who is the counsel?
Counsel
Is there contact
SMT 60 and F for the respondent, my lord.
Okay.
Yes.
So let him come. Wait,
No, my lord, next, another दिन, my lord.
that's what, another date.
Yes,
Let
yes,
him
yes.
come. We'll consider when he comes.
Yes.
When
Next.
can we list it? When do you want it?
Any date, my lord.
Next,
Mm.
Tuesday.
Next week, my lord.
Next Tuesday.
Next Tuesday.
All right. What's his good name? Mr. Chisi.
Yes, yes, I am appearing on behalf of SMT 60, madam. And my name is Yu Sharma.
No, correct. You're not appearing in this case, isn't it?
No,
Mr. SMT Chisti, Learned Counsel for the respondent. Right. Is unable to reach the court due to heavy rainwater logging. On a mention made on his behalf, list this matter again on 27th of May 2024.
Plus, in this matter also, instruction is awaited, my lord, so sometime it's required, my lord, here. I am appearing on behalf of the respondent number 1, my lord.
How much time?
2 weeks may be granted.
2
my lord.
weeks. Mr. U. Sharma, Learned Counsel, appearing for respondent number 1, submits that he may be granted further 2 weeks' time to obtain instructions in the matter. Considering the prayer, list this matter.
My lordship, that may be fixed, lordship.
Sorry,
That may be fixed.
list the matter. again on 4th of June. All right. Next.
My lord, in this matter, I am appearing on behalf of, for respondent number 2, my lord. Here, although I have received one instruction, but it is not up to date, my lord. So sometime may be granted here.
So similar issue under the same judgment usually,
Same date, okay? Same order.
same. Part of one.
You are respondent for respondent number?
Aye.
2.
Yes.
Ma'am, you can get one. This will be 2.
Order.
Made, your lordship, I could not go to the office, no lordship. I could not go to the office, no lordship.
Please write down. Office note dated 17/5/2025 indicates that neither ID card nor unserved notice has returned back from the sole respondent. So under this circumstance, office to track the postal consignment and put up a note by the next date.
Kindly fix it.
List the matter. Again. On 2nd June
Lordship.
2025.
Oblige, your lordship.
May I please, your lordship.
Mm.
The case of compassion appointment lordship,
Who's for the other side? All respondents? Oh,
Not all lordship, forest is there lordship.
you're for forest?
And for 5, 6 and 2 lordship. DLC and chief secretary lordship. Forest department is there lordship.
lordship.
Who's the for the forest department? Any councils?
I'm not sure, lordship.
Forest council?
Mr. D Gogoi, he is appearing representative. lordship.
D Gogoi.
Lordship.
B Gogoi or D Gogoi?
D Gogoi, Dixit Gogoi.
He has not come?
Lordship, I have not seen him. I will just cover case lordship and dispose of it lordship on the basis of this.
Covered case?
lordship.
So first you tell me what kind of case is this?
Lordship, yes. Lordship will see the para 9 or Roman 1 lordship of this judgment lordship. Already all cases has been disposed of lordship on the basis of this judgment lordship.
No, you first you
Yes,
tell me,
yes.
tell me the facts of your
Right.
case.
Taxi lordship, his father lordship died in the year 2015. And immediately lordship, he filed application seeking appointment on completion ground lordship. However, that was lordship overlooked and it was misplaced lordship. Subsequently, when this petitioner lordship visited the office of responding authorities and he was informed that lordship his application has been misplaced and he was asked to lordship submit another application. Then lordship in 2018, the subsequent application was filed and that was considered by the lordship authority, but it was not informed to this petitioner. Lordship, thereby lordship, this petitioner again approached this court for disposal of his application,
This is the third round,
second round lordship.
second round.
Lordship. First order lordship will find at page 32,
The first writ petition was what? 6061?
6061.
Then what is this 4804?
The last order lordship.
4804 of 2016?
This was some other case lordship.
Some other case?
Yes.
Okay.
Issue was same lordship.
Okay, 6061, where's the order?
Yes, page 32.
32.
Lordship.
We were asked to be given the copy of the,
Yes. According to
Outcome.
it was provided to us,
okay,
and
then
what you will find at page 36. it will also-
36.
Yes. The relevant portion of page 36 minus of the DLC. And his case was rejected at CL number 2,
Column, which column?
column number 2. Lord.
Two lordship.
What is the name of the petitioner?
Visit Kolita. In a guidance at number 1 was,
Abhijit,
yes.
late submission of
Yes.
application.
Plus.
So you said you submitted in time.
This is the second time application was, because first application was immediately the premises office further, but that was misplaced by the authority lordship. But unfortunately, the copy of the same was also not with the petitioner. So that was the problem in the first litigation.
So how do we know that you have
Yes.
submitted your first
Yes,
application?
it was submitted, lordship. He has given the statement in this petition as well as the first petition also, he has given the statement that yes, he submitted.
And what is the response by the respondents?
No response at all, lordship.
They have
Even
not
the-
received.
Yes,
They deny.
they have lordship.
When did you submit?
Lordship, date and the application of first application is also not with this petitioner. That
Then-
is the problem.
How do we know then?
Yes, but one thing.
Simply saying I submitted will not do.
Lordship,
This
one-
department has not submitted the affidavit also.
One thing is that lordship, consider one thing.
Hmm.
In the forest department lordship, basically, what happens is that all cadres are state cadres. There, all applications should be placed before the SLC directly, not before the DLC. So in this case, lordship, this petitioner's application was placed before the DLC, and DLC has rejected lordship. Whereby DLC has no lordship locus to reject his application because
Which application?
the petitioner's application that I have.
The second one.
Yes, lordship. Because it should have been placed before the SLC.
How do you say that?
Lordship, yes.
There's a separate guidelines for
Yes,
forest.
lordship, correct. Single copy lordship, kindly read the.
Why didn't you file this along with your writ petition?
Lordship, because this requisition I have filed by another set of council lordship, I have prepared letter on lordship. The first paragraph lordship will find specifically mention that all applications should be placed before the SLC lordship.
What is this document?
This is the minus of the SLC, whereby lordship, all applications have been considered by the forest department in 2015. From 1996 to 2010, all pending applications were considered in the year 2015 only.
Do you have a copy?
Lordship, but here now only one.
You have a copy, only one.
I have the extra copy, so I will get it. In the chamber, lordship, I have copy.
No, so that we can read together. That's why.
In the first
You have
paragraph,
only one copy, you hand it over, then you're asking me to read all these things.
yes.
Second thing, you'll give me another copy of another order and ask me to read.
Lordship, yes, I had the copy, lordship.
So you are putting pressure on the court
Lordship, I have the.
to read all your documents for
I have
you.
the copy, lordship.
So please read.
Yes. A meeting of the state level committee was held on 1st of April 2015 in the conference room of the Chief Secretary Assam at Dispur. A list of all present in these meetings is appended. At the outset, the SLC reiterated the fact that the requirement for recommendation of the candidates through a district level committee doesn't apply as the cadre of the employee of forest department is maintained at the state level and not at district level. The appointing authority for the post of grade 3, grade 4 in forest department is the PCCF and not the district level officials. Keeping this in view, the requirement for recommendation by the DLC for the forest department has been dispensed with by personnel department UO number 215207 dated 25/6/2007 and government direction issued by FRE number so 11/7/2022. These two notification lordship, separate notification was issued stating that lordship, since the all cadre of forest department are state cadre, their application for compensation appointment should be lordship considered by state level authority, not the district level authority. And here in this case, lordship, forest department, since 1996 up to 2015, no appointment was made, lordship. All applications were kept pending, lordship. Only on 1st of April 2015, all those applications were considered altogether, lordship, and this is the minus phase.
So what is the decision taken by this meeting?
Thus, they have stated that lordship, in this meeting, lordship, one,
What was the purpose of this meeting?
only to lordship consider all those applications which were pending since 1996. Lordship will find in the first page, bottom portion, lordship, selection of the committee for the year 1992.
So this meeting was held after your father expired.
Yes. No, before expiration of my father's.
Your father expired on which date?
First lordship on, oh, sorry, lordship. February,
13
yes.
13
After-
February.
After demerger of my father, yes.
Meeting was held on 1st of
Yes,
April.
later on it was held.
Your your application was considered by this SLC? No.
Not at all, it was never placed lordship before the assets.
So your first case was that you submitted your application. Meeting was held on 19/6/2018, but outcome not given
Yes,
to you.
yes.
Then afterwards, outcome is given to you. And they say that your application is belated. And today you are saying that my application ought to have gone to the SLC, not DLC.
Yes.
So who told you to submit before the DLC then?
No, lordship. We did not say to the authority to place our application before the DLC. We
Where
just,
did you submit?
it was lordship the concern, DFO, it will be DFO lordship. Yes.
So what can be done now?
Lordship, all the cases have been disposed of on the basis of this judgment, lordship. This judgment that I have referred. So, lordship,
Yes.
dispose of this, holding that,
Let us understand the judgment first.
Yes.
Simply giving a copy of an order saying that we have to be disposed of in this
Right.
similar lines cannot make any sense to this court.
paragraph number 9, lordship. Chapter 1, Roman 1, lordship.
What is this impugn OM dated 18/4/1924?
It did that, lordship, that notification was issued by the authority, government, lordship, government of Assam, stating that all those application has been lordship pending since long back, were not required to consider. So that application was challenged before this honorable court, and honorable court has lordship passed this order.
This OM dated 18/9/24.
Yes. This notification was challenged, lordship.
In which case?
In this case, lordship.
Where's the mention about this OM?
In paragraph number 8 also, lordship, that notification is mentioned. Council for the petition have submitted that they were agreeable to the proposal made by, yes. Then paragraph number 6 also, lordship, is mentioned. And the paragraph number 2, lordship, was also mentioned. Paragraph number 3 is important.
So this covers your case also.
Lordship.
Why was it not taken up on that day?
On that also, because it was not listed since 2023, Lordship. And others matter were checked regular, Lordship, but this was,
So the legality of that particular OM still remains. It has not been set aside.
it has not been set aside, Lordship.
Hmm.
But but you will see the paragraph number 8, the learned Lordship, Advocate General of Assam, he has given this proposal, Lordship, and on the basis of this proposal, it was disposed of.
See, it goes, says, without going further into the
Yes.
issue as to whether the OM dated so and so is bad or not, it would be proper to refer the proposal made by the AG,
Yes,
which is to the effect that the applications for compassionate appointment in relation to cases which are pending in this court challenging the OM dated so and so shall be considered by the shall be considered by the concerned authorities on merit. The same would be done by taking into account the various guidelines.
prior to 1/4/27.
But things that in your case, your application has been rejected.
Yes, but we have challenged that Lordship rejection order, but minus of the DLs. So this case also, paragraph number 9 also says same things. Paragraph 9, subparagraph 1 also.
Have you challenged that OM also?
We have in this case, we have not challenged.
You have not challenged. Then
Lordship, kindly see the,
how does it cover your case?
Lordship, kindly see the language, Lordship. Para 9, Roman 1, I am just reading, Lordship.
Hmm.
All applications for compassion appointment submitted by the petitioner shall be considered and disposed of by the concerned DLC SLC on merit by taking into consideration the various guidelines prior to 1/4/17 laid down by the state government for compassion appointment and the judgment of the Honorable Supreme Court and the High Courts. Consequently, Lordship, the rejection of all compassion appointment by DLC and SLC which have been put to silence and are pending in the High Court as on 3/4/25 are set aside. So already, Lordship, by this line, Lordship, what I have understood, Lordship, the rejection of DLC has been already set aside. Kindly, Lordship, see the which have been
What does
put
it
to
mean?
silence.
What does it mean? Earlier, there was already rejected. Again, one more direction is given to reconsider.
Reconsider,
On
because
what basis?
if Lordship allow me to place this thing like the minus of the SLC on 1/4/2015,
Hmm.
because the Forest Department, Lordship, I have already read out that Forest Department, there is no provision of GLC. It's a first thing, Lordship, because this case was filed by other advocate, Lordship, I was not there initially. Now, because I am handling other cases of Forest Department and I am getting all these orders, Lordship, based on the same order, Lordship will find another order, Lordship. Right, Lordship. This is also.
Yes, ma'am, would you agree?
There is no Lordship.
Lordship, I am for the DLC, Lordship.
Hmm.
And this is our instruction, which says that it is after passing at the 1 year time. Lordship. So it is a late submission. Regarding the submission of the first earlier notice, earlier application, Lordship, that part has to be clarified by the department, Lordship. Therefore, the presence of the CE forest is required, Lordship. Only the department can clarify the matter that whether it is the application was earlier also placed or not, Lordship. As per my instruction, Lordship, it was placed after 1 year. So it is late submission, Lordship. That's why the DLC didn't consider the application, Lordship.
Post it off then.
Lordship can dispose of considering the records only that was clear, Lordship, nothing more, Lordship.
What is your good name?
J. Kolita, Lordship.
Heard Mr. J. Kolita, learned counsel for the petitioner, and Miss
A. Talukdar,
A. Talukdar, learned government advocate,
government advocate,
appearing for respondent numbers
2, 5, and 6.
2, 5, and 6. None appears for the remaining respondents. Stop. Having regard to the projection made by the petitioner, the writ petition is taken up for disposal at this stage. We'll stop next para. This is the second time the petition is before this court. Stop. The first writ petition being WPC number 6061 of 2022 was disposed of by order dated 21/11/2022 by directing the respondent authorities to communicate the outcome of the decision held by the DLC, which held its meeting on 19/6/2018. Stop. The petitioner was thereafter accordingly communicated the DLC decision dated 19/6/2018, wherein it was remarked that the application of the petitioner is rejected due to late submission of the application. Stop. Mr. Kalita, learned counsel for the petitioner, submits that, in fact, after the father of the petitioner expired, died in harness on 13/2/2015, the petitioner had immediately submitted his application for compassionate appointment. Stop. However, a copy of the same was not retained by him, which led him to file his second application. To stop, the learned counsel submits that at any rate, it is not the DLC, but the SLC who should consider the case of the petitioner, since his father was an employee of the Forest Department, working as Forester Grade 1. Stop. In this connection, the learned counsel has referred to the meeting minutes of the SLC for appointment on compassionate grounds dated 1/4/2015. Which was chaired by the Chief Secretary, Government of Assam. Stop. A reference was made to the communications dated. No, communications. No, you can strike out that. A reference was made to personal bracket capital B departments apostrophe S, UO number 215/207 dated 25/6/2007, and the government's direction issued by FRE 105/2004/246 dated 11/7/2007. Wherein the requirement for recommendation by the DLC for the Forest Department was dispensed with. keeping in mind the fact that the appointing authority for the post of grade 3 and grade 4 in the forest department is the PCCF and not the district level official. Stop. Therefore, the requirement for having a recommendation by the DLC does not apply to the cadre of employees in the forest department. Stop. The learned counsel for the petitioner therefore submits that in view of such instruction, the case of the petitioner should be considered by the SLC and not by the DLC. Next para, the learned counsel has also drawn the attention of this court to the order dated 3/4/2025 passed by a coordinate bench of this court in WPC number 342 of 2025, open bracket, Abdul Qadir Bokshi versus State of Assam and 4 others, close bracket, wherein a number of cases were disposed of by a common order. Stop. Challenge made by the petitioners therein was to the OM dated 18/9/2024, which before that, you write, by which the scheme for compassionate appointment had been done away with for all those family members of the government servants who died in harness prior to 1/4/2017. To stop, this court, by taking into account the proposal made by the learned Advocate General Assam on an earlier date, which is to the effect that all the applications for compassionate appointment in relation to cases which are pending in this court challenging the impugned OM dated 18/9/2024 shall be considered by the concerned authorities on merit. Stop. The same would be done by taking into account the various guidelines for compassionate appointment prior to 1/4/2017 that were applicable in the state of Assam, and the various decisions passed by the Honorable Supreme Court and the High Court. So accordingly, the said bunch of writ petitions was disposed of. In terms of the direction passed in paragraph 9 of the said judgment, which is being abstracted as below. Paragraph 9, okay? A to A. Next para, considering the above submission, the present writ petition appears to be squarely covered as well, and accordingly, the same is being disposed of in terms of paragraph 9 of the order dated 3/4/2025, which is abstracted here and above.
Give you applied.
Nice, Lordship.
Milord, with the consent of other side, Milord. Matter may come up on Tuesday next, Milord. I have some personal difficulty today, Milord.
What do you say?
Tuesday, 27th. 27th or 29th of.
Any objection?
Oh,
Okay, on the request of Mr. PJ Pukan, learned counsel for the petitioner, list the matter on 27th of May.
Most of them.
May I please, your lordship? Lordship, yesterday we had filed an affidavit in opposition. Respondent number 1 had filed an affidavit in opposition, your lordship. It is not on record, your lordship.
Have you served copy?
Yes,
Have you
yes.
received?
Yes.
You want to file a rejoinder?
Can it be next week, my lord, any day? In the meantime, the affidavit will come into record.
That will come. I'm asking you, do you want to file rejoinder?
2 weeks time may be given.
2 weeks time.
Fine.
Okay.
After 3 weeks, any date may be fixed, man.
Ms. D. Musari, learned counsel appearing for the respondent.
Respondent number 1, your
Number
lordship.
1 submits that she has filed the counter affidavit of respondent number 1 yesterday. To stop, however, the records, however, the affidavit, the counter affidavit is not found in the records. Office to verify and connect the same to the records and list the matter again after 2 weeks.
Can be on 29, man.
Two weeks is not 29.
On 3rd, my lord, on 3rd.
On 3rd of
There is a
June
th-
2020.
Because 3rd round of
Right.
litigation, my lord.
The petitioner will be at liberty to file rejoinder affidavit in the meantime, if so advised.
Okay.
Obliged, your lordship.
May I please, your lordship?
Yes,
As per earlier order, my lord, I was informed by respondent number 3, my lord,
Mm.
that affidavit has been filed by respondent number 3 yesterday, my lord.
Mm.
Records have not come, but I may be allowed 2 weeks time to file counter affidavit.
have you received copy
I have received the copy, my lord. But so that's
by
why-
respondent number 3?
3, my lord.
You are for respondent number 3?
7. I am on behalf of 7.
7. And you are for?
Okay.
But she has not, he has informed me yesterday, my lord, that he has filed an affidavit. I may be allowed to file.
You have received a copy.
I have received the copy.
You want 2 weeks
I will-
for rejoinder. Counsel for the petitioner submits that she has been served with a copy of the counter affidavit filed by respondent number 3. And that she may be granted 2 weeks' time to file a rejoinder. Stop. It is however seen that the affidavit in a position of respondent number 3 is not on record. Office to verify and connect the same to the record. List again after 2 weeks.
Let's you can include in the 10 days, lordship. There's get interim order, lordship, since 2023, lordship.
I see.
That's it.
The interim order may be continued, my lord.
And that may be fixed, lordship. Otherwise,
3rd June,
As for the.
3rd June. List the matter on 3rd June, 2025. Interim order passed earlier shall continue till that.
Right.
All right.
Put the matter, sir. Highly obliged.
Actually, kindly pass over the matter for the timing, madam.
Before you started submitting, I could understand what you're going to submit. Why do you want timing?
My
Who's-
senior is on the way, madam.
Who?
S doctor.
All right, timing. None appears for the petitioner when the matter is called. List again after 4 weeks.
Please, my lord, we are for the petitioner. And that she'll be paying for some time.
My senior is out of station.
Who's your senior?
PKC.
How much time? How much time do you want?
My lord, can it be on 17th of June, my lord? 17th of June.
PK Sai kya?
PKC.
VK, Vinod Kumar. Singh.
VKC
PB.
or BKC? It's for
Can
1
it
to
be on
4.
17th of June, my lord.
Yeah. All right. It's okay, 17th of June. Mr. BK Singh, learned counsel for the respondent numbers 1 to 4 is said to be out of station on a prayer made on his behalf and not objected to by the other side. List the matter on 17th of June 2025 as prayed for.
I'm for the writ petitioner, my lord.
Yes, Mr. S. Chakraborty, learned counsel appears for the writ petition.
Let's not show.
Sorry, madam. In this matter, madam, I'm appearing for responding 5, 6, and 7.
Which one?
Item 11.
For the state of Arunachal.
Oh, history of Arunachal.
Arunachal is a party.
Yes, madam.
Yes.
Because Arunachal is the lending department.
One more line, Mr. M.R. Adhikari, learned counsel appears for respondent numbers
5, 6, and 7.
5, 6, and 7.
How like you?
It is item 12, is it?
That's it.
You are for the respondent?
That's it.
What is this matter regarding?
They have challenged the inquiry proceedings, sir.
Inquiry.
Inquiry proceedings.
He has been punished.
That's it.
How?
Some senior on legs, I conduct the brief after some
Okay,
time.
you are for which respondent?
Respondent number 1, Assam Gramin Bank.
Some Gramin Vikas Bank. But counsel for the petitioner is not here, what to do? He is supposed to lead the case. You are supposed to respond.
That's it.
None
Okay.
appears, what to do?
A date may be fixed. That's it.
None, date, or we adjourn it? We will not fix a date. Is there any interim order operating against you?
No, no.
Okay, none appears for the petitioner when the matter is called. However, Mr.
A Dhanuka.
A. Dhanuka,
That's it.
learned counsel appears for the respondents. For ends of justice, matter stands adjourned to be listed again after 4 weeks.
May it please your lordship. Lordship, conducting counsel, Mr. N. Rekha is on legs. Can it get passed over for the time being?
Okay,
May I please,
Lordship? Lordship, there is a instruction in the last order that the respondent number 2 and 3 supposed to find the details of the payment that they are going to release and the pending dues that are yet to be released. But they are failed to submit those details. There is a time period also that was mentioned in the last order, but they repeatedly fail to submit any document as well as required information.
what is this matter regarding?
It's a removal of service. Actually, they took the took the authority, the respondent number 6 took the authority without having any required rank and position. The initial action issuing so quotes as well as memorandum of charges itself is unlawful as well as unconstitutional. So the subsequent action are supposed to be invalid, but they try to manipulate the issue by suppressing material and fact by and some by giving some misrepresentation. on the issue.
Removal from service.
Yes, sir.
What service is that?
As a PSU, Lordship, I was in the position of as a manager of marketing in Numaligarh Refinery Limited.
Refinery.
Yes,
Manager, marketing manager,
yes,
refinery. You have been removed.
yes,
So you have challenged the disciplinary proceeding.
yes. Already, actually, I appeared, but the inquiry officer also, as well as not only the respondent 6, the inquiry officer also suppressed the issue and manipulate everything, Lordship. They did not follow a single CDR, and now they could not confirm anything in this honorable court, Lordship. Lordship, kindly pass an order so that they repeatedly violate even order of this honorable court.
Now, which order has been violated?
Can you give us some minutes?
Lordship, Mr. Deca has got the instruction. Can you get pass over for the time being?
No, I know.
Press the code.
So you're saying that some order has been violated. What is that? Standing counsel NRL will furnish details, particulars of the payments made to the writ petitioner by email by the next date of listing. These amounts which the petitioner person claims to be entitled to in his representation. Are you talking about the details?
Yes, Lordship.
This-
Lordship, this is not the first time the Learned Council of Respondent number 2, 3 tried to defer the hearing. For around 6, 7 occasions, he tried to defer the hearing by giving.
No,
some-
don't mix up the submission.
Yes,
First of all,
The instruction.
you confine to what you just said.
Yes.
That
Lordship.
something has not been given to you. What is that?
Lordship, kindly refer to the order dated to 29/09/2023.
29,
09/2023.
23. Yes, pendency not a bar to release you the amount. That is the order.
29, that was the previous order, Lordship. The next one, Lordship,
You-
29/09/2023.
Exactly, that is what I'm telling you. 29/09/2023.
Yes, sir.
It says any medical reimbursement amount pending should be released to you.
Yes, Lordship.
In the meantime, there's no bar.
Yes, Lord.
So
Then subsequently, they did not submit anything, Lordship. Then again, this honorable court on dated 06/12/2023.
26,
12/2023. The last para. The last para of the order.
26 or 6.
06/12/2023.
Correct, 06.
Kindly refer the last para, Lordship.
Shall also apprise the court regarding claim of medical reimbursement or any amount of salary or other dues that has been left to be paid to the petitioner. This one?
Yes, Lordship. Then they after that, they did not follow this order also, Lordship. They did not submit anything, Lordship.
So let the
Sir,
counsel
they-
come, we'll ask him.
Lordship, kindly pass an order so that.
My lord, he's at code number 4.
Please understand what he's asking. He's saying pass over for the time being. We're not adjourning the matter. Let the counsel come, we'll ask him why this order has not been complied with. All right?
Okay.
You be here around? Yes. 13. Passed over for the time being.
May it please, your lordship.
Yes.
My lord, the petitioner before your lordships, they are the son, daughter, and wife of the deceased. Now, my lord, the allegations against him, your lordship will find in the article of charge at page 30.
What is this disciplinary proceeding,
A disciplinary proceeding.
service matter?
My lord.
And why is it pending for such a long time?
My
2012?
lord, sometimes back, my lord, it was dismissed for default. Then we are not knowing, then we filed an application for restoration, it was restored.
How long was that period before restoration?
That period will be nothing. over it. Dismissed for default. 1 year and odd. my lord. Now, the charge your lordship will find, the punishment imposed is totally disproportionate.
Mm.
The lordship will find the charges at page 30, my lord.
Mm. 1 year, 2 months.
Yes,
It was dismissed on January 1824,
right,
restored in March 1725.
my lord.
First of all, you show me your initial appointment. What sort of appointment was given to you? This is FCI.
FCI.
Okay. Your the penalty imposed upon you is reversion
Yes,
to a lower post.
yes.
Are you still in service?
No, no, no. He's expired.
Oh, he's
Now his wife
Oh,
and the children,
okay,
they are
okay.
there before lordships.
Okay, I see. Substituted.
Yes, yes.
They have been substituted. But the name remains still as Bhavan Chandra Basumatari.
No, that has been changed, my lord. Now it's a Khargeshwari Basumatari.
But where is the amended post title? It is not there. Original is still there. Bhavan Chandra Basumatari. Anyway, if you say it has been amended, then okay.
My lord, if your lordship, the relevant part in the chart is
Just a minute. Huh?
that
It is written by hand. Khargeshwari. There are 4 petitioners.
4 petitions.
Number 1 is the wife,
Wife,
and the others are the son and daughters.
son and daughters.
Let us start from the beginning, the story.
We can start from the article of charge.
No, the employment. What was he doing?
That your lordship will find at page 27. This is not employment, this is the charge given by the district manager. And close, please find here with regional office, Guwahati memorandum under section 58. We are directed to submit within 10 days of the receipt of this memorandum, a written statement of your defense, and also to state whether you desire to be heard in person. Please acknowledge receipt of the triplicate. And then your lordship will find at page 28, the memorandum under rule 58. Anderson proposes to hold an inquiry against Sri So-and-so, AGA, Lead Depot in charge, DECOM under regulation 58 of the Food Corporation of India Discipline Appeal Staff Regulation 71. The substance of the imputation of misconduct or misbehavior in respect of which the inquiry is proposed to be held is set out in the enclosed statement of charge in Annexure 1. A statement of imputation of misconduct or misbehavior in support of each article of charge is enclosed in Annexure 3. A list of documents by which and a list of witnesses by whom the articles of charge are proposed to be sustained are enclosed in Annexure 4. Sri B.C. Basumatari is directed to submit within 10 days on the receipt of this memorandum, a written statement of his defense, and also to state whether he desired to be heard in person. He is informed that an inquiry will be held only on receipt of those articles of charge as are not admitted. He should therefore specifically admit or deny each article of charge. The Bashamatari is further informed that if he does not submit his written statement of defense on or before the date specified in para 2 above, or does not appear in person before inquiry authority or otherwise fails to refuse to comply with provisions of regulations, so and so, or orders, direction issued in persons against him ex parte. Attention of Sri Bashamatari is invited to regulation so and so, under which no corporation employee shall attempt to bring any political or outside influence to bear upon any superior authority to further his interest in respect of matters pertaining to his service under the corporation. If any representation is received on his behalf from another person in respect of any matter dealt with in these proceedings, it will be presumed that Sri B.C. Bashamatari is aware of such a representation, that it has been made at his instance, and action will be taken against his for violation of the regulation 50. Then you also will find the statement of article of charge at page 30. Sri Bashamatari AG1, while posted at FSD DICOM and functioning as depot in charge during the period from December 96 to November 97, had failed to discharge his duties properly, maintained absolute integrity, devotion to duty, perform duties honestly, and due to adopt malpractice, huge quantities of storage loss of food grains were occurred at FSD DICOM, which was detected in course of investigation conducted by a team constituted by the concerned district manager. By the above act, Sri Bashamatari, the Didian depot in charge, FSD DICOM, exhibited lack of integrity, supervision, devotion, duty for this lapse. Sri Bashamatari, Didian depot in charge, FSD DICOM, contravened regulations so and so, and thus liable for disciplinary proceeding as per provision of FCI. Now, from here, your lordship will find the competent authority made up their mind of guilt. The language clearly stipulates that, my lord. Then your lordship may turn to page 31. It is alleged that Sri Bashamatari, while functioning as depot in charge under district officer Dibrugarh during the period from December 96 to 97, and committed following irregularities and made him liable for ignition of disciplinary proceeding against him. It is alleged that huge quantities of storage losses of food grains were occurred at FSD DICOM within a short span of storage. It is alleged that while there was no operation in the depot, huge quantities were saved and consumed in the depot. In some cases, bags shown as refilled more than the stocks issued on that day. The ledger shown some stocks appears to be more than 2,000 bags, which is against the prescribed limit of the FCI. And there is every reason to believe that the stock ledger has no relevancy with the physical stock. It is also alleged that equal number of gunnies were saved and consumed, though there was no empty gunny in the depot. The stacks were intentionally not filled and issued the stock from several stacks, keeping all the half, which is objectionable. Further, it is also alleged that in several occasions, the ledger figures were either tampered or erased by erasing fluid. Now, these your lordship will find the percentage of loss. The details of findings of stock-wise loss in course of investigation conducted at district level shown here under. Now, in the right-hand column, extreme right-hand column, your lordship will find percentage of losses starts from 3%, then 1.4. Likewise, your lordship will find sometimes 2.75, 1.39. And only in one occasion, my lord, in November 1997, it was 15%. Otherwise, these are all in permissible limit. Now in page 34, your lordship will find 3 witnesses were named. Out of these, number 1 was not examined.
Number one, not examined.
Not examined. Number 2 and 3 only examined. Then the finding of the disciplinary proceeding by the inquiry officer at page 35. Your lordship may start from second. Whereas an
Page.
inquiry under page 35, my lord, I am reading.
This is the inquiry report.
Yes. Whereas an inquiry under regulation 58 of the FCI staff regulation 71 has been initiated against Sri Bashamatari at present assistant manager, white number so and so. Whereas SK Dev retired SP have been appointed as an inquiry authority to inquire into the charges framed against the charge officer, Sri Bashamatari, Sri FCI and Sri Rathin Barkatoki, assistant manager, what he was appointed as the prosecuting officer of the case. The charge framed against the CO in brief is that while Sri Bashamatari was in charge of FSD DCOM for the period from, it should have been from 96, my lord, December 96 to November 97, had failed to discharge his duties properly, honestly, and absolute integrity and devotion to duty. Due to his malpractice, a huge quantities of storage loss occurred at FSD DCOM, which was detected in course of investigation conducted by a team constituted by the concerned district manager FCI. Sri Bashamatari, the depot in charge FSD DCOM, exhibited lack of integrity, supervision, devotion to duty, and thus himself liable for disciplinary proceeding as per provisions of FCI staff regulations. Though the case has been received by me on so and so, but due to some technical difficulties like collection of listed documents from vigilance cell, the actual inquiry into the charges commenced from so and so with the examination of the listed prosecution witnesses. The corporation has cited the name of 3 officials only to prove the charge framed against the CO besides listed documents, but out of those 3 PWs, only 2 PWs have been examined and cross-examined. The gist of their deposition furnished below. Now, PW1, Sri so-and-so, stated in his deposition that as per order of the then district manager, FCI Dibrugarh, along with the assistant manager, an assistant manager had investigated the cause of storage loss at FSD DCOM, and what he had found that was incorporated his investigation report, which may be treated as Exhibit P1. Now, my lord, the record will be necessary. What is stated in Exhibit P1, your lordship can see.
Report is there?
This witness PW1.
Records are there. Records are seen.
PW1.
Please mark all these things, exhibit P1 and all that, so that we can have a look.
It's there, my lord. My lord, may I just interrupt you for the subject one? My lord, the last occasion preliminary objection was raised because, my lord, the petitioner, the impugned order is passed in 2000, my lord, 5. And he has filed the writ petition in 2012 after his retirement. So, Fred was asked to explain, to show the delay, my lord, to explain the delay. It was not in so many words explained. That is one thing. Second thing, my lord, the petitioner is expired. The prayer made in the petitioner is to get back his job in the post, the post he had. This prayer, my lord, I think, my lord, has to be amended because this prayer cannot be granted by your lordship now.
We are not asking for that.
That prayer, and that prayer has to be made, my lord.
Reinstatement.
Prayer is, my lord, prayer of in the writ petition is to restore the petitioner to his post which he held. So, my lord, this prayer, my thing, my lord, your lordship may not be able to grant to the petitioner. This is my lord, friend can continue. But I think when I must point out to your lordship at the very beginning.
The question is such a
And
unreasonable
number,
pair.
second is, my lord, the delay part. Delay part is after 5 years, my lord, after retirement, is suddenly impugn order is 2005. I'm 2005 and filed the writ petition 2012, challenging that order. So that, my lord, I think lordship at the very beginning has to, my lord, consider.
My
if
lord, I
lordship
can
is satisfied on
explain
that.
that to your lordship. That question was raised by the honorable court, not by my learned friend. Now therefore, my lord, the court asked me whether the explanation is there. The lordship will find explanation is paragraph 21 of the writ petition. And regarding prayer, my lord, I am yet to say what is my prayer. Because the person died, I cannot ask for as a petitioner what he wanted. Now my prayer would be, my lord, if there is any financial benefit I am entitled to, that your lordship can only grant. Otherwise, I cannot ask for, my lord, whatever the prayer I made in the writ petition on behalf of the deceased.
All right, you continue.
Now, my lord, your lordship may look at the prayer for condemnation that was there. Paragraph 21, no?
Page 21, I've seen it. Medical problem,
It's all right.
3 years and all that, and some lack of fund arrangement and all that.
But these are technical in nature, my lord. I did not.
You go ahead, we'll consider everything whole in one.
Yes, yes.
After hearing everything, we might dismiss it on delay also, we don't know.
It's up to your lordship. my
Yes,
lord, the
so
which one-
you complete your part.
Right. Now, otherwise, my lord, I'll say there is a totally, when there are appeals court decision.
Ah.
If there is an acceptable explanation, it is up to the court. My lord, I read at page 36,
Yes,
PW1, Sri so and so stated in his deposition that as per order of the then district manager had investigated the cause of storage loss at FSD Decom, and what he had found that was incorporated in his investigation report, which may be treated as exhibit P1. Now, that exhibit P1, your lordship is required to see what they have stated there. During cross-examination by the CO, he admitted that the investigation was done as per leisure. Then this is only the, my lord, the explanation by the PW1. Then PW2, Sri Pavitra Kumar Borua, the then assistant manager, Dibrugarh, stated in his deposition that as per order of the authority, he along with Muhammad so-and-so and Sri P.D. Hazarika had investigated the cause of storage loss at FSD Decom during the material perused, and what he had noticed that had been incorporated in the report submitted to the authority, which may be exhibited. He also stated that during these investigations, Sri Bashumatari was in charge of FSD Decom. The other witness, Sri P.T. Hazarika, could not be examined as he had gone on retirement and did not turn up for deposition. In the reply to the memorandum, the CO, Sri Bashumatari, has taken the plea that the Decom godown is located in a rural area without boundary walls and proper electricity. As a result, a miscreants take the opportunity to pilfer stock from outside. This matter was taken up by the authority concerned, but no suitable action came to notice. The watch and ward staff of Decom informed their inability in performing duty at night to the MDFCI, New Delhi too, but to no effect. There are birds trouble too, and since the godown is not conventional, the rainwater logging during monsoon causing variation of moisture of the stock inside the godown. During inquiry into the charges framed against the CO, Sri Bashumatari, the investigation report dated so-and-so, submitted by the investigating team, has been taken into consideration besides other records and the deposition statement of the witness. The CO was given ample chance to cross-examine the prosecution witnesses, but he could not refute the charge brought against him by those PWs who had actually investigated into abnormal storage loss shown by the FSD Decom. In the reply to the memorandum, he also indirectly admitted the charge brought against him showing some practical difficulties faced by him, which said to have been communicated to the higher authority of FCI inviting the CEO, also did not bother to submit his defense brief till date. In view of the above, it could be said in the finding that the charge frame against the CEO Sri Vasumadhari found to have been sustained. Now, we find we gave a reply to the inquiry report. Lordship will find in the page 38. To the General Manager, in response to inquiry report against the memorandum of charge sheet mentioned above, I am furnishing my reply comments as below. The quantity of storage loss occurred during December 96 to November 1997, as shown in the statement of imputation of misconduct and misbehavior that is annexed to and closed along with the memorandum under rule so and so dated 10th February 2003 has already been sanctioned for written off by the competent authority by regional office letter dated so and so. As per procedure, regions responsible for storage loss were considered to be genuine by a team of officers at district office FCI Dibrugarh. Under the provision of headquarters circular, they found losses to be reasonable and thereafter they recommend the case to the district manager FCI for onward transmission to the competent authority for written of regularization. Similarly, in the regional office, DM scrutinized, examined thoroughly and recommended those cases to senior regional manager, Sri so-and-so, written of the entire losses as mentioned above. Under the circumstances, I am not at all liable to bear the responsibility of losses since those were occurred due to various reasons which were duly considered by 3 assistant managers at Dibrugarh district office, district manager Dibrugarh, deputy manager regional office, and finally by the senior regional manager. If I am to be answerable, then the aforesaid officers will also be liable for their unlawful activities. In this context, it may be mentioned that prior to December 1996 and after November 1997, storage loss at FCI DICOM were on higher side and competent authority also considered regions responsible for such loss as reasonable and genuine and gave sanctions for written off. As for example, during February 1998, losses were high, that is 4.4%, and senior regional manager FCI gave sanction order for written off white number so and so dated 23rd December 2001, which is higher than losses occurred during the December 96 to November 97. From the aforesaid facts, it is not proved that I failed to discharge my duty properly. Now, Your Lordship, kindly note this fact. The relevant time, my lord, I will take to other annexures also. These, the laws, what they say, that it varies from, my lord, sometimes 3%, sometimes 1.5, sometimes 2.5. Now, and ultimately the sanction was made to write off these losses. Then even after that in after 98, Your Lordship will find that 4.4 losses were also incurred and which are sanctioned by the authority that to write off those losses.
In yours, in your case, it was 15% in one time.
In one time, it is 15%. In other maximum period, if Your Lordship take the average, it will be 3%, sometimes 1.5, sometimes 2.5, and only one occasion it is 15%. And there are reasons why it is hiked up to that. And in spite of the fact that there was no fencing, there was no boundary wall, the even night guard did not do any duty for, my lord, the threatening of the gundas from the outside who used to pilfer all this.
So that's why,
I'll take Your Lordship.
no, that's why in the beginning I asked you,
My lord.
what are you, how are you appointed, what is your function? Because your nature of your duty and responsibility will also be a relevant factor
Yes.
for the loss.
I'm the in charge and I'm not the only person there, my lord.
You're the only
There-
person there.
No, I'm not the only, but there are other person also, and they have not been. my lord.
What are you? What were you? Assistant manager?
I'm the assistant manager in charge of that depot at the relevant time.
Assistant manager in charge of depot. What is the depot?
That is, my lord, there is a storage of food grains there.
No. Name, which place?
It is Dibrugarh.
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 Name
Yes.
of the depot?
Yes, that is there also written, maybe that just. Decom. Decom, my lord, that's Dibrugarh.
Decom.
Decom.
Where do you get that?
DIKOM. Is there, it is written.
Where do you find any document?
Yes, yes. The chart sheet your lordship will find.
From the chart sheet.
On the top, my lord, statement of articles of charge claim against the so and so. Then depot in charge of FSD Decom,
Page.
page 3030. On the top, my lord. Statement of article of charge claimed against the so and so. Then depot in charge of FSD Decom under district office Dibrugarh.
FSD means food security deposit.
Food storage.
Food storage depot.
Food storage depot.
Decom.
So this is my reply. Then, my lord, your lordship may see at page 40 the punishment order.
Page.
Page 40.
Is the penalty.
Yes, order dated 19/9/2005.
19/9/2005.
Yes. Whereas disciplinary proceeding under regulation so and so, following charges, huge quantities of storage losses of food grains were occurred at FSD Decom within a short span of storage during the period so and so. While there was no operation, your lordship may skip that. Then your lordship may come in the middle. The charge officer Sri B.C. Bashomatari, assistant manager, was given an opportunity to personal hearing which was held on 25/7/2005. During personal hearing on 25/7/2005, Sri Bashomatari, the then depot in charge, FSD Decom, given the opportunity to speak freely if anything has to be submitted by him, but he could not submit any reply or written statement during hearing. The undersigned gone through the articles of charges, reply of charge sheet, inquiry report, and the relevant documents of the case. The facts remains that Sri Bashomatari Didan so and so shown the storage losses of food grains were occurred at FSD Decom 3% to 15%. Now, your lordship, kindly see the camouflage. They're showing that it is 3% to 15%, but out of so many occasions, only once it is 15%. Maximum 3%, then there are sometimes 2%, sometimes 1% also. Within a short span of time, that is December 96 to November 97. It is a fact that while there was no operation in the depot, huge gunnies were saved and consumed in the depot by Sri Bashomatari, even bags shown as refilled more than the stocks issued on that day. Equal number of gunnies were saved and consumed, though there were no empty gunny in the depot. Based on the records, inquiry proceeding, careful consideration of facts, circumstances is revealed, and after application of mind, I, functioning as disciplinary authority, of considered opinion that a penalty of reversion to the next lower post of AG and placement at the minimum of the basic pay in the scale of so and so till retirement would meet the ends of justice.
What is full form of AGI?
AGI post of AG ki hoga?
It's AG1. AG1, assistant grade 1.
The lowest post.
System grade 1 and D means depot.
D means depot.
Depot.
Very sure.
He was an assistant manager.
He
So
was
the next lower post is AG1,
AG. And below that, AG2,
AG2.
and then AG3.
Okay. 3, 2, 1.
3,
Then
2,
assistant
1,
manager.
and then assistant manager is the managerial category.
Okay.
Now, therefore, the undersigned in exercise of power conferred under regulation 56 of FTI hereby imposes the penalty of reversion to the next lower post of AG1, the placement at the minimum basic pay. Then I filed an appeal, which your lordship will find at page 42.
There's no discrepancy on the date, isn't it? It's 19/9/2005, is it?
Yes, yes. 19/9, that is correct.
19/9/2005.
2005.
Okay. Then you file an appeal.
An appeal which your lordship will find at page 42. To the managing director, with humble submission and due respect, being highly aggrieved by the order dated 19th-9/2005, passed by the Zonal Manager Guwahati, whereby the penalty of reversion to the next lower post of AG1 and placement at the minimum basic pay in the pay scale of so and so till retirement with immediate was imposed against me. I beg to pay for appeal. That sir, the senior regional manager FCI Assam region, by his order dated 23/12/2001, accorded sanction to write off the storage losses occurring from December 96 to February 1998, after the same being recommended by the district manager, Dibrugarh. A copy of which is enclosed, that sir, as per section 15(4) of the FCI circular number so and so dated 24 December 1999, the time schedule for regularization of storage shortages and or taking disciplinary action is that the higher competent authorities are to take decision to write off losses and or to take decision for disciplinary action against delinquent officials after receipt of each case from the subordinate authority is to be done within 60 days. But in my case, the write of storage losses for the period from December 1996 to February 1998 was sanctioned on 23rd December 2001. In place of 6 months, my lord, they have taken a long 2-3 years. Whereas disciplinary proceedings against me was initiated on 10th February 2003, white memo dated so which is a gap of 1 year and odds, and far beyond the period prescribed in the aforementioned FCI circular. As my submission before your honor is that the disciplinary proceeding initiated against me is a gross violation of section so and so of the FCI circular dated so and so. That's as per section 14(2) of the FCI circular dated so and so. The competent authority is not convinced about reasonableness and justification of losses. He should get the cases investigated and take a view for initiating disciplinary action against the delinquent officials, who is prima facie found responsible for such losses and thereafter write off the losses. But in my case, disciplinary action against me was initiated after the write off the losses in gross violation of the FCI circular. The competent authority has put the case before the court, put the cart before the horse in my case. That, yes.
What do you mean by this sentence? That loss was for between December 96 and November 97.
Yes.
Then disciplinary proceedings started with the memorandum in 2003,
Yes.
February. So before that, it was already written off or what?
Right. My lord, before the inquiry coming to end, my lord, they have written off the losses. Now they are satisfied with the reasonableness of the loss. Therefore, they have written off.
Before the inquiry came to an end
Yes.
or before the inquiry started? Which one?
No, it's in the midst, my lord.
During the
Because-
midst of the inquiry, they
Yes.
wrote off.
They have written off the losses because they realized it was maybe natural consequence. So therefore.
But still they proceeded to
They
penalize.
still have
penalize.
proceeded, and even in, I have shown in my reply that even a case where the loss was 4.4, that also they have written off, and there was no disciplinary proceeding in that particular case. No,
Yes, please continue.
now, hence, in my case, the right of storage losses for the period from December 96 to February 1998 was sanctioned on 23rd December 2001, whereas disciplinary proceeding against me was initiated on 10th February 2003. It was after written off, it was written off on 23rd December 2001. Then disciplinary proceeding started on 10th February 2003. Even after more than 1 year.
From where reading?
That page 43 in the middle, my lord. But in my case, from there.
Yes. Okay.
But in my case, The right of storage losses for the period from December 96 to February 1998 was sanctioned on 23rd December 2001, whereas disciplinary proceeding against me was initiated on 10th February 2003. White memo number so and so, which is a gap of 1 year, announce, and far beyond the period prescribed in the aforementioned FCI circular. Hence, my submission before Your Honor is that the disciplinary proceeding initiated against me is a gross violation of the section so and so of the FCI circular dated so and so. That, sir, as per section 14 of the FCI circular dated so and so, if the competent authority is not convinced about reasonableness and justification of losses, he should get the cases investigated and take a view for initiating disciplinary action against the delinquent official who is prima facie found responsible for such losses and thereafter write off the losses. But in my case, disciplinary action against me was initiated after the write-off of the losses in gross violation of the FCI circular. The competent authority has put the cart, it should have been cart, my lord, before the horse in my case. That, sir, as per section 15 of FCI circular dated so and so, disciplinary cases under major penalty are to be decided within 240 days. But in my case, the disciplinary proceeding was initiated on 10th February 2003 and decided on 19th September 2005. That is after a long gap of 2 years and 6 months and beyond the prescribed period of 240 days. That, sir, it is stated in the right of sanction order of storage losses dated 23rd December 2001 that the district manager is to identify the officials and issue show cause notice for the high losses and has to forward the show cause reply to the regional office with his comments for taking further appropriate action within 2 months. But in my case, this was not implemented. That, sir, I was promoted in 2000 to the post of assistant manager after the storage losses for the period from December. Now, your lordship kindly see, 2000 he was promoted. After this period of losses, that is December 96 to February 1998, was promoted in the year 2000. That, sir, the reason responsible for occurrence of storage loss was very much reasonable and justified, which can be substantiated with the losses occurred before December 1996 and after 1997. In this context, Your Honor may further investigate from the books of accounts of Deccan Depot. That, sir, as regards the condition of godown and its location, I have specifically mentioned ground reality of material periods in my reply in response to Senior Regional Manager FCI circulars dated so and so. Further, I request Your Honor to see the things at DECOM and verify about the condition of hired godown. I believe will consolidate your juristic personality. The copy of my reply has been xeroxed and enclosed for your ready dated so and so reference, which is marked as Annexure B. Hence, my submission is that the instant punishment of reversion to the next lower post of AG1, retirement till retirement, and placement at the minimum basic pay in the pay scale of so and so till retirement for the storage loss of December 96 to February 1998 is highly disproportionate, inasmuch as the instant case I have been penalized in a very harsh manner if it is calculated in terms of money. The instant punishment has caused great financial loss to me because of after my retirement, this will adversely affect my pension benefits to a great extent. That said, the entire disciplinary proceeding is without any basic whatsoever, and the same is absolutely void and fit to be quashed. Under the circumstances set forth above, I humbly submit and fervently pray before Your Honor that entire proceeding against me be quashed in the order dated so and so passed by the General Manager, imposing penalty of reversion to next work post of AG1 and placement at the minimum basic pay. The pay scale of so and so till retirement be set aside. Then, my lord, your lordship will find at page 47
47.
That order have been maintained.
What is this order?
This is the order by the
Disposing the appeal?
managing director, yes.
Appeal.
Your lordship will find the operative part at page 48.
See, one thing which you have mentioned here that the loss sustained by that for that particular period
Yes.
can be explained by the loss sustained previous to that. What do you mean by that?
Lord, your lordship will find in my reply, your lordship can see.
In your,
At
in your appeal at page 44, paragraph 7,
Page 44, paragraph 7.
that sir, the reason responsible for occurrence of storage loss was very much reasonable and justified, which can be substantiated with the loss occurred before December 1996.
Now, my lord, I'll take your lordship to certain papers.
You're trying to say that this loss is being going on and on.
Yes. I'll take your lordship to the papers are here already. Now, your lordship may see at page 48, the operative part.
48,
Yes.
yes.
I perused the charge sheet, inquiry report, order of the disciplinary authority, all relevant record leading to the case, an appeal petition preferred by Sri Bashumatari. I observed that the storage losses occurred was ranging up to, my lord, they are always up to 15%. Only one occasion it arose.
Okay, just a minute before that. Your appeal is dated 7/11/2005
Yes,
and disposal of the appeal is 21/11/2006
yes.
after 1 year.
After 1 year.
Is it correct?
Yes, your lordship will find my appeal is 7th November 2005.
Hmm.
And it was disposed of on 21/11/2006.
2006, okay. Appeal rejected.
And rejected because all the time, my lord, they are highlighting that 50 losses up to 15%. Now, they are not showing the earlier period that sometimes maximum time it is 3% and sometimes 2%, sometimes 1%.
No, up to means what? From 0 to 1, 3, 4, up to 15%.
Up to 15%.
That variation.
Yes, the loss sometimes occurred, say in a given month, it is 3%.
No, correct.
They are highlighting only 15% while rejecting the prayer.
No, it says ranging up to 15%. There's the highest limit.
Highest level.
The lower limit will be maybe 1% or something like that.
One occasion 1.5, another occasion 2.5 in few occasions,
So-
maximum 3%.
So it does not mean that every time it was 15%.
No,
It means up to
So therefore, my lord,
the highest level they have shown.
highest level they are showing to, my lord, give me somehow some punishment. And why all this thing occurred, my lord, I'll satisfy your lordship. Possibly your lordship will rise now.
Yes, I'll rise for 5 minutes and come
Yes.
back.
Yes,
Does it come?
yes, come.
Yes.
My lord, now I'll take your lordships to page 49. That is the right of sanction of storage losses. At page 49, your lordship will find.
Page 49.
In exercise of the powers delegated by the headquarter New Delhi circular under so and so, the storage losses percentage value, this they have given the storage losses value. Then the aforesaid right of sanction is subject to non-involvement of CAG and without prejudice to the action pending contemplated for fixation of responsibility in any vigilance cases, theft, fraud, negligence against any officer or officials related to the losses which may arise now or at later stage. The district manager Dibrugarh will identify the officer, official and issue show cause notice for the above high losses, should forward the reply to the show cause notice to the regional office with his comment for taking further appropriate action. Now it is up to the disciplinary authority. They may go for further disciplinary action also.
What is this non-involvement of CAG means?
This is CAG, that is my lord, involvement of CAG.
Audit objection.
Audit and without any other prejudice to the action which is contemplated by the authority. Now, in spite of, my lord, they, by this circular, they want to show that in spite of the fact that it has been written off, still it is up to the disciplinary authority. If they want to go for disciplinary proceeding, it is open to them.
Writing off will not debar the proceeding.
Exactly.
Hmm.
Now, what is the reason behind for all these things? Your lordship will find, I will take your lordship now from page 52 onwards. The lordship will see the date 7th April 1993. The storage place was in a dilapidated condition. The request was made by the authorities to
51.
make the repairing to the owner of the. Your lordship will
Page
find it-
number 52.
Page 52. The 7th April 1993. Two
But this
messages
was long time back. Who has written this?
is the melody, it is
District
addressed,
manager.
district manager Melo.
District
the-
manager is above you.
Yes, above me. Is informed to the owner of that particular godown. He is Messrs.
In DCOM.
DCOM Melo. Messrs. Khemani proprietors, owner DCOM FCI godown, Madawadi Patti, Dibrugarh. You have been requested several times to construct boundary wall around the DCOM godown to prevent entry of outsiders in the godown campus, but no action appears to have taken by you till date. Due to insecure position and condition of the watch and ward staff of the godown often reported entry of outsider miscreants at night into the godown campus and creating trouble. Moreover, the office accommodation and the main gate has not yet been completed till date. The construction work of the main gate watch point and the office accommodation has left half done for more than a year. Kindly note that without proper secured condition of the godown in an urban area like DCOM, retention of the godown by FCI will not be possible, and we shall have no alternative but to recommend to our authority for the release of the remaining godown. As such, you are hereby asked to complete the above works by May 1995 positively and report compliance. Then the next, your lordship may turn to page 55.
No, just a minute.
Yes.
We shall have no alternative but to recommend to our authority to release for releasing of the remaining go down.
Right.
Means that you'll not occupy the go down
Yes.
because of the condition.
Because of the condition.
Okay.
It has been from the very, very long past, my lord. Then the same, at page 55, your lordship kindly see, there is the letter dated.
54 is the type, the
54
original
is the
copy.
Original one, we have
Okay.
typed it.
You have read the type copy.
Yes, yes. Then page 55. This is the letter dated 8/4/1996. Addressed to Messrs. Khemani, that is the owner of the FCI godown.
Oh. Yes.
Dear sir, with reference to the subject cited above, I am to inform you that roof leakages in different spots at A shed and B shed of this godown have been noticed, but it has been observed that in spite of our repeated request, you are taking no any interest for repairing the same. Therefore, you are further requested to make necessary arrangement to repair roof leakages at an early date. Further, this is also inform you that rainwater is pouring on the different stocks at this depot due to roof leakages. This is for your prior information and requested to attend personally for immediate repairing of roof leakages, and if any damaged food grains will found due to pouring of rainwater on the stock of food grains, you will be informed to attend depot at the time of segregated assessment of damaged stock. Then at page 57 is the letter dated 18/3/1996 to the Kamani Enterprise. With reference to the subject cited above, I am to inform you that there are so many leakages on the roof of the godown. The drop of water stain the food grains bags in many stacks. So you are hereby requested to pay a visit at Decom Depot, make immediate necessary arrangement for repairing of roof leakages of the godown. If any damage of food will be noticed due to pouring of rainwater, you'll have to face for this. You are therefore requested to take up the repairing works of the godown without loss of time.
Who has written this letter?
This is written by Depot in Charge Food Corporation of India.
Is it the petitioner?
Yes.
Late
that-
petitioner?
That relevant in Asile, no? 96? No, 96, no. He
Hmm?
was not, he came in the last part of 96. It was the earlier Depot in Charge, maybe.
Okay, the previous incumbent.
Yes,
And the earlier letters were written by the technical assistant.
technical assistant. Earlier one is technical assistant.
Then before that, district manager.
Yes,
They are all from the same report.
same depot. maybe.
District manager, technical assistant.
Right.
But then why the blame only goes to the assistant manager?
My lord,
Because he's in charge of the thing.
he is in charge, that's the reason only. Then at page 59. Ivan, Imane. This is the letter dated 7/5/96 by the previous incumbent. Technical Assistant Depot in Charge FCI intimated by letter dated 25/4/96 that a quantity of 1.51, 1.53 of rice have been damaged due to roof leakage and pouring of water in stack number so and so. In spite of several correspondence reminders, the godown owner did not take any initiative to repair the godown leakages, due to which the damage of so and so of rice may please be deducted from the godown rent bill of the said godown owners. This thing have been happening for a long time, Melu.
How much is the amount? 1.5, 51 quintal.
1 point is a percentage of loss, Melu, quintals, yes.
Percentage or it's just 1.5?
1.51. Now that should be deducted from the rent of the owner. That was
1.51 quintal means how much? 1.5 bag.
that whatever the price comes, the loss of that may be deducted from the rent. That was the proposal given by the assistant manager.
No, that's what. The damage caused by the rainwater is only 1 bag, 1.5 bag.
Maybe that,
1.51 quintal.
yes.
1 bag is 1 quintal. Generally.
No, this is they will measure, my lord, 1.5 quintals. It comes.
What is
for-
this bracket N?
My lord, my learned friend is representing the corporation. He may say better, my lord. N ki hai? Anyway, my lord, I am taking your lordship to page now 59. This is also addressed to the owner of the, my lord, the godown.
But
Please
there
ref-
is that copy is not there, isn't it? Type copy. Where's the original copy of page 59?
Page 59. This original copy, my lord, is not here,
Is not there.
not there. It was sent, it wasn't? No.
So all these are letters for repair and all that. What you want to project is
Well-
that because of the go down
By
condition,
This I am
loss has been
projecting
sustained.
because there is no wall, the miscreants can enter into the premises very easily. And even the night chowki, the night guard and all these people scared to remain there. Now, these are the circumstances, my lord, the loss have been occurring, not once, for all the time to come. And my lord, the letters were given to the owners by the authority also to make a repair, but no such steps ever been taken. And ultimately, my lord, these person have been made a scapegoat. And your lordship, if
How much was the total loss as per the proceeding drawn against you?
this, my lord, your lordship will find in that page. They have given a chart, my lord.
Percentage, 3 to 15%.
Percentage, yes.
And
This is starts from page 32 up to 33. They have given just percentage in a
only percentage. What is the total weight? Not given.
total. Percent.
You have to
The content.
you have to add all this. The second last column
Yeah.
is the storage loss, and the weight is given.
Storage loss, yes, the quintals system is there. Say December 96, 3%, that is 41.22 quintals.
It's quite a bit, you see, 41.22 quintals, 19.65 quintals,
Yes,
40.20 quintals.
now this loss is not, my lord, because of this in charge. Because in that depot, there are so many other persons also. If this really occurs, not only it cannot go only up to me, there are other staffs also there.
What is your defense? Have you said that in your defense?
No, my lord, these things, of
You have not
course,
said anything,
it has not been there.
that I'm not the only person here. There are others also.
Even otherwise also, my lord, in a office, he is not only the one person. If any, this sort of pilferage are there, it with the collaboration of all. And these letters, what I have shown to your lordship, this shows that the condition of the godown is also not up to the mark. It happened due to all these also. And the letters, my lord, and the last letter which I'll take your lordships to show that at page 67. This is by the petitioner, my lord.
See,
Addressed to the city.
Mr. Datta, you have mentioned about these letters. You have shown me 3-4 letters.
Yes,
Where have you stated that this in your annexure 3? Reply,
in reply, my lord.
yes. That go down is very bad, in the bad shape, so this has contributed to all this loss.
Hmm.
You have given 2 pages reply.
Yes, yes.
There's no mention, anything about that sort of thing.
Your lordship is that way correct, but then cumulative assessment, if your lordship makes, can it be just for my fault? Your lordship has seen, these are the letters from right before that date also. And we have been informing, the authority have been informing to the owner of the godown that make a repair.
I understand, but there should be at least one line, one sentence. My go down is very bad.
Your lordship is very right, because they could have hesitated all this thing in their reply. But then it's not there, but then ultimately, if your lordship look at the entirety of the matter, these papers are considered, punishment given, it is a really disproportionate one. I'm not saying that I'm really very, very innocent. But the cumulative assessment, if it is made, with the corresponding document which I have taken to your lordships. It gives an indication that the shape of the godown is not proper at all. And this has compounded the loss of all these things because of the condition of the godown.
All right.
Now, if your lordship look at page 70 also,
70.
that is my, before that, my lord, 67 and 70, your lordship just
Hmm.
see. Page 67 first is by the petitioner to the senior regional manager. As desired, the lordship got that.
Yes.
As desired, I have the honor to lay before you the following few lines and facts in support of high incidence of storage losses. That said, the Godam Decom is located in a urban rural area without boundary wall. There is also fact that arrangement of electricity practically nil. As a result, the miscreants outsiders take opportunity to pilfer stock through ventilators at night. That said, the watch and ward staff of the Decom Godam informed their inability for night duty, black and white, to district manager several times. It is fact that there is always conflict between miscreants and watch and ward staff. Some of the watchmen injured in the conflict also. The district manager Dibrugarh has taken up the matter with local police authority for night patrolling to safeguard the national property, but suitable action has been taken from the end. The matter was also informed to union people also in black and white. The godown is located in urban area in gathering of huge birds are natural. It may be also fact that due to birds travel throughout the year, a huge quantities of stock might have lost because of the broken ventilators. That's why the owner of the godown compelled to close the windows by brick and cement, only to save the food grains from miscreants. As a result, proper aeration is not there. The moisture reading at the time of receipt and after completion of issue of particular stock shows 0.4 to 1.3 shrinkage in wet, which is also a fact of losses. The unloading points are not constructed with brick and cement and not covered by shade. The godown is not conventional, plinth is very low. During monsoon, rainwater lodged on the side of the godown, and due to high temperature inside the godown, bottom layer bags and uppermost bags dried up to great extent. That said, the period of storage ranges from 1 month to 1 year. Due to long storage, some quantity of stock might have lost. Then, my lord, the last letter, that is at page 70.
This happened after it was written off.
Yes, yes. Now
Order is written off, then why did you write one more letter?
no, the condition of we are just showing how the losses occurred. It is not up to me only. It is the circumstances prevailing and the authorities keeping mum. They are totally silent, although they know that the godown is not up to the mark. There is no repairing. They could have, my lord, changed the godown. They could have shifted somewhere. They did not do it. And the page 70, this is also letter to the chief regional manager by the petitioner. The similar type of letter, your lordship can see that. Now, if your lordship, the evidence, whatever is there, my lord, I did not have those papers with me. Your lordship can see the record that exhibit P they have referred and the ledgers in order to show that really they have stated something in evidence. Your lordship is exercising power of supervisory jurisdiction only, that I am conscious of. But still then to appreciate the evidentiary value, since my lord, what has been referred in the inquiry report is not clear at all. This gives an indication that he has stated in exhibit P. They did not discuss what is exhibit P. Therefore, it is necessary that your lordship may see that whether they have clarified by stating what is there in the exhibit P.
Exhibit P1 is the report.
P1 is the report and
P1.
they say they from the ledger, then my lord, if they produce the record, what is exhibit P and what about the ledger? Because they're saying during cross-examination by the CO, he admitted that the investigation was done as per ledger. Now, what is stated there in the ledger and what is there in the exhibit P1, these are the vital papers which your lordship may like to see.
Yes. Anything else?
My lord, that's it. And another thing, my lord, your lordship will find that page 30. My lord, what is contemplating the mind of the authority? My lord, competent authority already made their mind, the guilt of the person is already playing in their mind.
How do you say that?
Page 30, your lordship, if I read the middle part, by the above act, Sri Bashamatari, Dedan depot in charge, exhibited lack of integrity, supervision, devotion, duty for this lapse. Now they have already made up their mind. And there is a decision of the apex court, my lord. Anything? My lord, I'll take your lordship to that judgment after some time. Let my learned friend finish his argument. On that point, my lord, I'll buttress my submission by placing a judgment of the apex court. I'll give it just after some time.
You're reading the second last paragraph. Has failed to discharge his duties, properly maintained
Yes,
absolute
yes.
integrity,
Yes.
devotion to duty, so and so, so and so.
Now, this is while they're articulated the charge at that point of time, they ought not to have uttered that, my lord. Because by saying that, you have totally made up your mind, the guilt of the charge officer.
Okay.
That's all. my lord.
Yes.
May it please lordship. My lord, if lordship kindly take up my written affidavit in opposition, I'll just read two paragraphs first and then I'll. Affidavit in opposition that filed on 23/12/2015. I will explain to your lordship how this story is lost. Could have happened, could happen. Lordship got it, no?
No, just a minute. Affidavit in opposition. Oh, yes.
My lord will come to paragraph 3. Or my lord, the preliminary objection that is given in paragraph 2, my lord, may I read it?
Yes, yes.
That the deponent at the very outset submits the petitioner being guilty of delay in laches is not entitled to relief from this honorable court. The petitioner has filed the writ petition in September 2012 by challenging an order of penalty passed against him by the disciplinary authority as well as the appellate authority for proved misconduct on 19/9/2005 and 21/11/2006 respectively. The petitioner has retired from the service in 2012. For long 7 years, when he was in service, he did not challenge the order of penalty, but soon after his retirement from his service, the petitioner has sought to implore the assistance of the discretionary power of the honorable court in respect to the cause which arose 7 years back. The writ petition is therefore so and so. Paragraph 3. that without prejudice to above, but nevertheless strongly relying thereon, the deponent begs to state that the charges drawn against the writ petitioner were very serious in nature. Within a short span of 1 year, that is from December to the 1996 to November 1997, when the petitioner was working as depot in charge of the AFCI food storage depot at Decom, a huge quantity of storage loss was detected. Even when there was no operation in the depot, a huge quantity of gunnies were recorded to have been saved and consumed in the depot. I will explain this, my lord. I will explain this a little later. In some cases, quantity of bags shown as refilled is found to be more than the stock issued. Some stacks appeared to be more than 2,000 bags, which is against the prescribed limit of FCI. The stock ledger and the physical stock did not tally with each other. To cover up the said apparent manipulation, depot ledger figures were found either tampered with or erased off by use of erasing fluid. There was 3 to 15% abnormal storage loss during December 1996 to November 1997. The petitioner's response to the charges in his written statement were all very flimsy and avoiding in nature, and not pointing to the charges, which reflects his admission of guilt. All these are proved during the domestic inquiry held against him by following due process of law. A full-fledged departmental inquiry was conducted in respect of the aforesaid charges by appointing independent inquiry officer where witnesses were examined and cross-examined. The documents exhibited were duly proved by the witnesses due manner and granting the petitioner due opportunity of hearing. After completion of the domestic inquiry, the inquiry officer submitted his report, which was duly forwarded to the petitioner. The petitioner has given his reply to the said inquiry report, but did not allege any procedural infirmity or prejudice in respect thereof. Finally, disciplinary authority, after considering each and every material and record, imposed the penalty of reversion to the next lower rank, Eastern Grade 1 depot at the minimum basic pay of the said post till retirement, which was also affirmed by the appellate authority as being justified and logical. After so many years, now the petitioner slept over and is right so and so now. Now, my lord, how this happens, my lord? When the stocks are issued to the state government authorities, the stock receiver, when they find the bags are torn, they do not accept this. Then what they do, there is a serviceable gunny bags. They change these gunny bags. When they use this serviceable gunny bag and give the stocks, we call it killing of stock, killing of gunny bags. And these torn gunny bags will be saved, gunny bags saved. So what they did, the stocks are kept in stacks, huge, maybe 100 feet by 200 feet, like that. So verification is made, peripheral physical verification is done. Not always 100% can't be. 50,000 metric ton. So what they do, they take out rice or wheat from the bags at the top and use these gunny bags, serviceable gunny bags, and take away. And solely, but they manipulate it. That's how the gunny bags are used. So here, the authority found on the same day when there was no operation at all, gunnies were used. Huge number of gunnies are used. That is the finding, my lord. I'll give your lordship that. And next, my lord will kindly come to paragraph 8. Lord, at page 5, lordship got it.
Yes.
My lord, that with regard to statement paragraph 14 of the writ petition, the deponent denies and disputes, save and except so and so. It is denied that the charges framed against the petitioner were absolutely vague and unintelligible, because of which he was derived of submitting an effective reply as a list. It is stated that right of sanction as accorded, was a routine administrative job, which always is made without prejudice the action pending contemplated for fixation of responsibility in any vigilance case. It is stated that the petitioner being depot in charge, he was in charge of the depot, in charge has all the responsibility in every transaction. Depot in charge was quite aware of the percentage of loss beyond 0.5%. Well, this loss or sometimes occurs because of dryage of grains, moisture content, dryage of moisture content, and rat troubles. So committee has found that the loss, storage loss beyond 0.5% is abnormal. He's aware. Every in charge of the depot is aware. So in his case, 3.5% rose up to 15%. So for dryage can't be 15%. Moisture content. Or rat troubles can't be 15%. So the minimum standard is 0.5%. Your Lordship has seen this, the storage loss as given in the statement, 3, 4, 5, and 15. Now, my Lord, I'll give you Lordship these are the circulars, my Lord. He's aware. I will place before Lordship circular, which says that 0.5% must be my Lord, taken to task. That is the, I'll give you Lordship that. Now, my Lord will kindly have a look at from the record. I'll give you Lordship the original record. But for your Lordship's convenience, now you My Lord, I'll hand up my one copy to my learned friend also. This is proved during inquiry. This is the part of the record.
What is that?
This is the investigation report which is proved during inquiry. Which is proved. I'll give one copy to my learned friend, because the proper my learned friend may also answer to this. My Lord, this is the investigation report. In pursuance to, this is P, my Lord, Exhibit P, the form part of the Exhibit P. In pursuance to your office note dated so and so, the committee consisting of estate manager accounts, estate manager storage, and estate manager quality control commercial has conducted preliminary inquiry into the storage loss shown by the depot in charge. DECOM depot during the period December 96 to March 97, September 97, December 97, and February 98. The depot in charge, DECOM during that period, Sri Bhuban Chandra Basumatari, that is the petitioner, deceased, Eastern Grade 1 depot. However, from 23/12/97 to 1/4/98, Basumatari was not present at the depot, DECOM depot, and Sri Dulal Hazarika, Eastern Grade 2 depot, after the works of depot in charge. During investigation, it was found that abnormal gunny were saved and consumed without any justified reasons. I told you, Lordship, the reason how the gunnies are required to be used. In some occasion, it is found that gunnies were saved and consumed on the date when there was no operation in the depot. Gunny cannot be used when there is no operation depot. In some cases, the bags shown as refilled more than the stacks issued on that day. As per ledger, some stacks appears to be more than 2,000 bags, which is against the prescribed limit of the FCI, and there is every reason to believe that the stock ledger have no relevancy with the physical stack. In several occasions, it is found that equal number of gunnies were saved and consumed, though there was no empty gunny bags at the stock. No gunny bags, it is shown in the stock, but it is used. These appears to be done for giving undue benefit to the laborers in any way of refilling the routine so and so. the storage loss detected by the depot in charge DECOM are extremely on the higher side in comparison with the other depots, and the mystery lies on abnormal saving of gunny bags, gunnies shown by him without justified reason. The depot in charge have intentionally not killed the stocks, instead shown issue from the several stacks, keeping all the stacks within all objectionable, which is objectionable. One district office PV squad conducted 10% verification of the following stacks and submitted their report to the regional manager so-and-so. But the depot in charge has shown some other figures in his ledger, ignoring result of the 10% PV. Hence, there is ample scope to believe that the ledger has been prepared ignoring the actual physical stock. In several occasions, the ledger figures are either tampered with or erased by erasing fluids. The depot of the findings text and enclosed hearing. The committee could not verify the gunny ledger to ascertain whether gunny shown, saved, and consumed actually accounted for in the gunny ledger, since the gunny ledger maintaining so and so. So, my lord, this is the report on the basis of which inquiry is conducted, and he could not, my lord, satisfy about this findings of the inquiry report in the inquiry. And my lord, you have seen the inquiry report. And my learned friend, my lord, basically, he says that is, my lord, is fair enough, my lord, saying that he has some lapses. My learned friend basically now is on the quantum. My lord, in this regard, I'll just, my lord, will have a look at the paragraph 7 and 8. Just, I'll be very short, my lord. In my submission, I'll not take your lordship's time any longer.
This is the exhibit P1, isn't it, which you give?
This is one of the exhibit. Exhibit 1 is the P1 is the 1, 2, 3, 4. Exhibit P is the prosecution documents. Exhibit P.
There's a mention of exhibit P1.
P1. It is
at page 36 of the writ
my lord,
petition.
it should be exhibit P10. It should be exhibit P10.
This one.
This one.
But where's the mention of P10 anywhere? Because in the report, findings of
No,
the
no,
inquiry.
I'll give you lordship the entire exhibits are marked as exhibit P, and from page 1 to page 36. Page P1, P2, P3, P4, P5, P6.
There's a reference of P1.
P1, but it should be, I think, P1 I find, P1 is the list of documents. P1 is the list of documents, my lord. P1 from the record is the P2 is the list of witnesses, like this below. I'll hand up to your lordship the original. Now, my lord, I'll read before lordship the investigation report that I've given is a part of this document. I have given it for a lordship convenience only.
Okay.
Now, my lord, paragraph. Paragraph 7. What's that? I have a different copy. I'll read from paragraph 7, lordship.
Yes.
Got it, paragraph 7. 2013 10 SCC, page 106.
Yes.
Now, my lord, it says, when the charge is proved, as happened in the instant case, it is the disciplinary authority with whom lies the discretion to decide as to what kind of punishment is to be imposed. Of course, this discretion has to be examined objectively, keeping in mind the nature and gravity of the charge. The disciplinary authority is to decide a particular penalty specified in the relevant rules. Host of factors go into the decision making while exercising such a discretion, which include, apart from the nature of the gravity misconduct, past conduct, nature of duties assigned, responsibility of the duties assigned to the charge, the depot in charge, the previous penalty, if any, and the discipline routine and the discipline required to be maintained in the department or establishment where he works, as well as the extenuating circumstances. All these factors are not before lordship to award any kind of other penalty. Now, next is the order of appellate authority, while having a relook of the whole of the case, would obviously examine as to whether the punishment imposed by the disciplinary authority is reasonable or not. If the appellate authority is the opinion that the case warrants lesser penalty, it can reduce the penalties so imposed by the disciplinary authority. Such a power which bears to the appellate authority departmentally is ordinarily not available to the court or the tribunal. The court, while undertaking judicial review of the matter, is not supposed to substitute its own opinion on reappraisal of facts. In exercise the power of judicial review, however, the court can interfere with the punishment imposed when it is found that totally irrational and outrageous in defiance of logic. This limited scope of judicial review is permissible, and interference is available only when the punishment is shockingly disproportionate, suggesting lack of good faith. Otherwise, merely because of the opinion of the court, lesser punishment would have been more appropriate, cannot be a ground for interference. My lord, this, your lordship, in my humble submission, is not a case where your lordship would hold that the penalty imposed is wholly disproportionate and defiance of logic. Therefore, the penalty and the appellate authority has given a relook, taking into consideration all factors and found that the penalty imposed is just and proper. By the disciplinary authority is just and proper. My humble submission before lordship, the lordship may not like to interfere with the penalty imposed, or there is no procedural infirmity. This is also not alleged also by the petitioner in so many words. Now, my lord, and my lord, now the question is, apart from the delay, now the question is, my lord, his wife is substituted. Penalty imposed is reduction in rank. My submission that I was, my lord, submitting for your lordship at the very beginning, therefore, the petitioner ought to have made a prayer after substitution that it is not automatic, my lord. Prayer has to be made. Writ petition ought to be amended after the so. It may, my lord, your lordship may see it to be very technical, but my lord, my submission is prayer has to be made. It is not automatic. And even otherwise also, what the petitioner will get now? She cannot go back to work in place of her husband. Pension, my lord, I am not sure whether it is, she is a CPF pensioner, then the pension is, I don't think she will get any better pension. Because CPF pension is very low. Contributory provident fund pension is not like with the government pension. It is given on the basis of last 10 months, not average, taking into consideration. And family pension is very less. And I think the pension she is also getting family pension under the CPF, the EPF pension rule 1995. And this the petitioner is a depot in charge. Depot in charge, I didn't have the, don't have that the chart. I have a departmental chart where the specific duties and responsibilities are given to everybody. And depot in charge has the main person mainly responsible for all the transactions in the depot. He cannot avoid just by saying that it is the amount is written off, so I should be absolved. It can't be below. And the storage loss, as I have shown to your lordship, is very huge. The standard is 0.5%, not above that. circular table. Lordship will have a look at the last paragraph. Whatever. Last para, my lord, of this para 9. Paragraph 9 at page 3,
Yes.
Lordship got it.
Yes.
It says the zonal managers, senior managers are also hereby advised to review the procedure adopted by them for such regularization in view of the decision of the chairman that for any storage transit loss beyond 0.5%, responsibility and recovery shall be ensured. There should not be under the mistaken impression that no such action need be initiated for losses that fall under their delegated powers for regularization, so writing off. That we have stated in our affidavit in opposition.
When did the petitioner retire?
He retired, my lord, on 30/6/2012. 30th June 2012.
And he expired on?
He expired, my lord, on 8th of October 2016.
So how much longer would you submit?
No, my lord, I will not travel any longer. Below, this is all.
Perhaps Mr. Datta will reply also.
He, my learned friend.
Just take 10 to 15 minutes.
We'll have to come back again to
At 2.
yes. All right.
8/10/2016 he has expired. As per their statement.
8/10/16.
Yes. Yes,
Retirement was 36/12.
that's right. 36/12. Well, Lord, before my learned, just one point I just want to add, my lord, just short point. With my learned friends.
Oh, yes.
My lord, as I said, my lord, the petitioner has been substituted. Her petitioner has died. His wife has, my lord, been substituted, or the children. It was an employment. It was an appointment. Employment is a status of a person, my lord. It is not a property right to succeed as such. It is not a property right to succeed. After his death, my lord, the cause of action, in my humble submission, does not survive any longer after the death. And she today, after she steps in the case, cannot seek to justify the misconduct, my lord, for which he was punished, to justify his conduct, my lord, now at this, because she was not there. It was not any order passed against her. And by the impugned order, only order of penalty was passed. No property right was taken away, so as to enable her to succeed and clean. This is my humble submission.
My lord, so far this question is concerned, law is no more res integra, my lord. This point has been decided long time back, that the deceased can come up. So for the financial benefit is concerned, they are entitled. My lord, if we are to go to that chapter, my lord, it will take some more time. The question is this, here we are asking for what? We are not asking for a moon. Now the question is, if the disciplinary proceeding is too harsh, it is disproportionate, that is one chapter. If the perusal of the charge sheet and the inquiry report shows that it cannot go on, My lord, your lordship kindly see what is the charge sheet. I will take your lordship to the, once again at the cost of repetition, to the enquiry report. They are saying, my lord, let me, my lord, come to page 30 of the charge sheet once again, my lord, your lordship, kindly excuse me for repeating. The charges, whether charges is specific or not. This is the basic requirement of the service cases, my lord. At page 30, my lord.
Yes.
Sri Bashumatari posted at so-and-so had failed to discharge his duties properly, maintain absolute integrity, devotion to duty, so-and-so, so-and-so. By the above act, Sri Bashumatari, the depot in charge. Now, these are the allegations, my lord. Then your lordship kindly see the next page. It is alleged that huge quantities of storage. Now see whether it is a specific charge or not. It is alleged that huge quantities of storage losses of food grains were occurred in FSD within a short span of time. It is alleged that while there was no operation in the depot, huge quantities were saved and consumed in the depot. In some cases, bags shown as refill more than the stocks. Now, these are called some cases. You must say how many cases on which date, whether he is directly implicated or not. Now, then, my lord, your lordship will find at page 34, list of witnesses only. There is no list of documents, or he is entitled to inspect the documents. So these are, my lord, the very basic requirements. Then your lordship kindly see the finding of the disciplinary authority at page 36. As your lordship knows, the recording for reason is sometimes considered as a part of natural justice. Now, whether, my lord, I will not say to reappreciate the evidence. I am not asking for that, as it will amount to sitting in appeal. Now, your lordship will not embark upon to do that. But then, if your lordship finds that there is no plausible reason why he is coming up to that finding, it is the bounden duty of the inquiry officer, my lord, to link. There's some evidence which links the charge officer with the misconduct alleged. Now, whether he could do that, your lordship kindly see at page 36 in the middle, PW1, so-and-so, as your lordship got that?
Yes.
The assistant manager FCI district office, Debriga, stated in his deposition that as per order of the then district manager FCI, had investigated the cause of storage loss at FSD Decom, and what he had found there was incorporated in the investigation report, which may be treated as Exhibit P1. Investigation report, your lordship kindly see. And I have seen my learned friend is kind enough to give me a copy of that. Now, I'll request your lordship to see that what they have stated there. In pursuance of your office note dated so-and-so, the committee consisting of so-and-so has conducted preliminary inquiry. Preliminary inquiry is a fact-finding body, my lord, into the storage loss shown by the depot in charge, Decom Depot, during the period December 1996 to March 1997, September 1997 to November 1997, and February 1998. The depot in charge, Decom Depot, during that period, Sri Bhuvan Chandra Bashumatari, assistant grade 1. However, from 23/12 to 97 to 14/98, Sri Bashumatari was not present at Decom Depot. And Sri Dulal Hajarika, assistant grade so-and-so, looked after the works of the depot in charge. During the investigation, it was found that abnormal gunny bag were saved and consumed without any justified reasons. In some occasion is means which occasion, my lord, whether it is in my period, because they are saying up to 1997 to December 97 and February 1998. Now, during that period also, one Mr. Hajarika has come. Mr. Hazarika's tenure is 23/12/97 to 1/4/1998. So therefore, he came in between, this person was also there. Now here in point number 2, in some occasion it is found that gunnies were saved and consumed on the date when there was no operation in the depot. Now which one is on that date? And whether this person, the petitioner was implicated or not, there is no such evidence on record. Then again, my lord, in some cases, the bags shown as refilled more than the stock issued. Now, your lordship will not find on which occasion those things arose. How you are implicating this petitioner? The entire episode of this the investigation report is false for these lapses. Therefore, if your lordship look at the report of the inquiry officer, he said it was found that was incorporated in his investigation report, which may be treated as exhibit P1. And the paper given to us, it shows P22. Now these, my lord, the hodgepodge things is never correlates that the evidences which were given by them, it has linked the petitioner, and therefore the evidence given has been established against the petition. Now what evidence is there? Absolutely nothing. The charge is back. Even the P1, whatever they are saying, it is the paper given is P22. Even if your lordship considered that, it will not, my lord, persuade your lordship to say that there is sufficient evidence to link the delinquent with the charges framed against him. The charge is back, as well as the investigation report is back, and nowhere it implicates the petitioner.
So the two witnesses which you examined,
Yes,
PW1 and PW2, are they supposed to be these two persons
Yes,
mentioned in
my lord,
this,
yes.
mentioned in this P1?
right. Your lordship may see the name of the witnesses as given in the list.
Yes, PW1 is AK Muhammad A. Ullah.
Right.
PW2 is Sri Pabitra Kumar Barwa.
Yes, yes.
Now, in the report of P1, that loose paper which was given to you
Right.
by the Learned Standing Council,
Yes.
first paragraph comprises of the three persons.
3%.
Preliminary inquiry. One is Assistant Manager A/Cs.
Yes.
And the other one is Assistant Manager QC,
Yes, yes.
Public Commercial. These two persons,
Now
the
these
the
two-
designation,
Yes,
they
No,
fit in,
no.
they fit in PW1 and PW2.
yes. And
They must be
if-
the ones.
If this can be constituted to be an evidence,
Hmm.
can it be said that they could establish anything against the petitioner? These are all vague statements they have stated in preliminary inquiry into the storage loss. And they have in between that time, there are two persons. Now, on whose date those things occurred?
What is
Yes.
this ledger? During cross-examination, the CO,
Yes,
I mean, the charge officer,
right, right. Yes.
he admitted that the investigation was done as per ledger.
As per ledger. Now,
What does it mean?
let them show what the ledger speaks.
Ledger is the register, my lord, ledger, book ledger. Ledger is the register where the things are recorded.
No, therefore, my lord, it is the bounden duty of the inquiry officer. He must explain it. My lord, what he want to say? Exhibit P1, he must have stated that PW1 stated against him, this is the specific evidence. Therefore, the evidence has been, the allegation against the petition established from the evidence of the PW1. He did say nothing, my lord. And during cross-examination by the charge sheeted officer, he admitted that the investigation was done as per ledger. That means by seeing the ledger, he has given the evidence. Now, what is there in the ledger? My lord, he should have clarified everything so that the delinquent understand what is against him.
Yes, Mr. Datta, anything else?
Yes, my lord, your lordship will see the PW two also. Pavitra Kumar Borua, so and so in his deposition that as per order of the authority, he along with so and so PW Hazarika had investigated the cause of storage loss. This storage loss means this paper which have they submitted. So there is no evidence such as implicating the petitioner here. And in the enquiry report, my lord, it is the duty of the enquiry officer. He must give his finding based on the evidence of the PWs. Now the evidence, so-called evidence, what they want to say, this is the evidence, is P22. It shows nothing, my lord, against the petitioner. They even could not say on whose date there was a loss of, and they said some occasion it is found that gynnies were saved and consumed. In some case, in some cases, the bag shown as refilled more than the stock issued. Now, these will have to be very specific if you want to make a linkage with the offense. That too with the petitioner. Now, these are all missing, my lord. Can you make such a vague allegation and implicate some person without any evidence? That is the question, my lord, falls for your lordship's consideration, my lord. The enquiry report is totally vague and furthermore, my lord, when you were saying in the enquiry report that PW1 and all this should have been given to the delinquent, my lord, it was never given to them. And in regard to, my lord, the filing of documents, furnish of documents, my lord, it is the appeals court, your lordship is already well aware. That has been said, the law is well entrenched that in any inquiry, department or management desires to rely upon any document in proving of the charge. It is incumbent upon them that the copies of those documents are supplied to the delinquent employee for satisfying principle of natural justice. The enquiry officer is an independent person and is not a brief holder of the department. He is a quasi-judicial whose functioning is to examine the presented by the department and to ensure even in absence of delinquent official that evidence before him is sufficient to hold the charges as proved. He has to follow the procedure and observe the principle of evidence for proving of documents. Now, my lord, I'll furnish your lordship to this judgment. You reported in. My lord, I'll furnish this document later on, my lord, by furnishing a copy to my learned friend also. This is all, my lord, your lordship may kindly see the entire P1 document series. Because ordinarily, my lord, I would not have requested your lordship to embark upon that aspect. Because the enquiry report shows they never appreciated the evidence on record. And they will have to establish the linkage with the offense committed by the petitioner vis-a-vis the evidence given. Now, these are totally lacking and the P20 document shows that these are totally vague. And furthermore, in the cross-examination, as your lordship has seen, they have stated that investigation was done as per ledger. Now, as per ledger, what is that only inquiry officer knows and the management knows. We're not in a position to know all that. And where you were relying on the ledger, exhibit P1, it was their bounden duty to give us those papers to us. That's all, my lord.
My lord, only my learned friend has said that document does not furnished. My lord, he has inspected the documents on 18/6/2003, my lord will find in the record. And furthermore, he has not annexed the written statement, my lord, in the writ petition, which is very much on the record. In the written statement also, he did not say furnish me documents. Thirdly, written statement against the charges, he has not annexed in the writ petition. He has not annexed. And all will not vex evasive. Now, my lord, inquiry, again, he has submitted representation and inquiry report. He did not say I was not furnished any documents. In appeal, he has not also said that I'm prejudiced, no documents are furnished. And in fact, he has, your lordship will find for the record on 18/6/2003, he has inspected all the relevant documents. That is quite on record. And my lord, it is a disciplinary proceeding, not like criminal trial, my lord. It's based on preponderance probabilities. It is not so much, but it has to be proved. That's all.
Provision 7 is page 90. Transmitting to.
My lord, just for a minute. I'll take your lordships to a judgment of the Apex Court 1998 7 SCC, page 84. I'll furnish to your lordships. Before that, I want to read that paragraph. Yes, I'll just give it to your lordships. A bare reading of the above regulation, this is the regulation of the bank, my lord. They have the regulation and it is the same contents it is there. The regulation shows that on furnishing of the charge sheet, full opportunity is required to be given to the delinquent officer to prove his innocence. This is a case where the disciplinary authority decided that procedure contained in regulation 6 be followed. Under regulation 6(2), the disciplinary authority, instead of conducting the inquiry itself, choose to appoint another person as the inquiry authority to inquire into the imputations of misconduct. On the conclusion of the proceedings in the manner provided by regulation 6, the inquiry authority has to forward its report to the disciplinary authority along with all relevant records. The said report has to contain the inquiry authority's findings on each of the charges. My lord, I am on this. The said report has to contain the inquiry authority's findings on each of the charges framed against the delinquent officer. According to sub-regulation 3, regulation 7, the disciplinary authority having regard to the findings on all or any of the articles of charge imposes any of the penalties specified in regulation so and so, this obviously implies that where the inquiring authority has found all or any of the charges proved against the delinquent officer and the disciplinary authority agrees with the said findings, then it can proceed to impose any of the penalties specified. Now, therefore, my lord, under their regulation, the similar provision is there. And they will have to show that the inquiry officer has relied on the evidence on record and whether he is satisfied with the offenses which has been established against the petitioner and they have dealt with the matter, and then only, my lord, proper punishment can be imposed. That is the question of law, my lord. The lordship can see that, my lord, that is quoted in paragraph 10. Didi. Paragraph 10, my lord, it is in regard to the regulation of Punjab National Bank. The parameter provision is there in the FCI regulation also. In all the service jurisprudence, my lord, that this is mandatorily given in all the rules and regulations. This also comes closer to that.
Why have you relied upon this judgment?
My lord, you also will find the finding of the inquiry officer.
Hmm.
Now, did he come to any conclusion that on the basis of the evidence given by PW1 and PW2, I come to the conclusion that in terms of that evidence, the offense has been established, I mean, charges has been established. These evidences, this finding has to be given by the inquiry officer. My lord, this is totally lacking in this. He has referred PW1 and then in the cross-examination, that investigation on the basis of the ledger. Now, does it inspire any confidence of your lordship that really the evidence given, it has established the offense against the petition? No, he did not come to that finding at all. That will have to be very, very specific, my lord. Even the charges are vague. The report of the inquiry officer is also vague.
Okay, that's it.
My lord, another paragraph I'll read of the coordinate bench. The interference in the present proceeding being on the ground that the inquiry officer had not recorded any findings and therein disclosed the reasons for the conclusion so arrived. With regard to the charges so level against the petitioner, the allegations so level against him being serious in nature and the same being required to be considered in a proper proceeding, this court hereby grants a liberty to the respondent to initiate Now that, of course, initiated de novo proceeding doesn't come here, since the delinquent has already expired. So, my lord, my submission is that since there is nothing on record, if it inspires confidence on your lordship, that's a different thing. But when there is no iota of evidence linking the petitioner with this kind of allegation, because when which date what happened, because your lordship will find 2% in between has come. I mean, one person, this is Mr. Hazarika. He was there up to April 1984, no? 98. Now he was also there. Now it might be so in some times means that occasion also.
April 98.
Yes, your lordship will find.
But the period is for December
Period is-
96
Yes,
to
your lordship.
November
I will once
97.
again, my lord, because I want to clarify that storage loss shown by the depot in charge DECOM during the period December 1996 to March 1997, September 97 to November 97, and February 1998. Another person from 23/12/97 to 1/4/1998. Sri Bashumatari was not present at DECOM depot, and Sri Dulal Hazarika, assistant grade so-and-so, looked after the works. Now, even Mr. Hazarika is not there also.
You're reading from this, what,
This
P1?
P22.
Huh?
They say in inquiry report it is P1,
P1.
but the paper given is P22. Now,
P-
even my lord, if your lordship look at number one, during the investigation, it was found that abnormal Gani were saved and consumed without any justified reasons. In some occasion, it was found that Ganis were saved and consumed on the date. Now, on some occasion is which occasion, on which date?
No, that you've already said. I
So
understand.
therefore, these are totally vague. How one can link the petitioner with this sum?
Okay, what is the criteria for drawing such proceeding? What is the provision under the FCI?
Well, they have the regulation, my lord.
What do you call that? What is the regulation called?
Should I give a copy to your lordship?
Yes, give me a copy.
I'll take back later. my lord.
Surely,
Oh.
you'll take it back. We want it only for
Okay,
perusal and for disposal of this case.
Yes.
Not
That's
nothing beyond that.
I know, my lord, but I lost many such books, my lord, in the past. 658. huh? Doesn't- Yes.
Any particular provision?
Regulation 58 by which we not say, regulation 58.
Regulation 58.
I'll give you also the book. Regulation 58 is the provision, my lord. At page 41, you also will find. And my lord, in the charge also, it is mentioned, it should be regulation 58.
What is the name of the regulation?
Food Corporation of India, Staff Regulations, 1971. I end up, because for your lordship convenience, my lord, one copy your lordship may keep along with the record. Copy दीजिए। हाँ। Request करो। Person more कोई नहीं। It should be page 31, no?
Page?
31, I think, my lord. Regulation 58, it should be page, at the bottom, page initials are given, no? Page. No, it should be, my lord, I'm sorry. Page.
Page.
My lord, page.
Yes, I got the regulation 58.
Yes. my
But the
lord,
page
at
number
page
is
41.
Page 41.
Lord.
This is for imposing major penalties. Then provisions regarding drawing of proceeding.
Misconduct, proceeding, this is the procedure, it starts at 58. My lord, no, the procedure are laid down in
So that is
58.
the penalty.
No.
Before coming to the penalty, what is the procedure?
Oh, these are the explanation, my lord, will find, and then regulation 6. In regulation 6, sub-regulation 6.
Regulations?
Sub-regulation 6, the disciplinary authority shall forward a copy of the article of charges, statement of imputation misconduct, is view a copy of written statement.
No, where is that? I
Oh.
don't find regulation 6. Appointing authority, regulation 6. Creation of post category.
Sub-regulation 6 of regulation 58.
Or of regulation 58.
Yes.
This is parameter material to the what this Punjab National Bank.
Punjab National Bank. Yeah. That, my lord, I'll check it up if my learned friend share his. Then I.
Normally, under any disciplinary laws,
My lord, I
with
have.
the Assam State Discipline Action, what we have
Right,
that
right.
rules.
Yes.
That thing is
Huh?
there. Under the CCS also,
Because
same
it-
thing.
It is the instinct of natural.
Charge,
judgment, my lord.
statements of imputation, misconduct,
It
everything.
is regulation 3, sub-regulation 3, 58(3).
All right.
Lordship.
My lord, I'll be submitting one decision, right?
On
One decision that I have cited, paragraph 28 of the coordinate.
of
bank.
this court.
No, my lord, is by Justice. Justice, you can add on this point that the inquiry officer must give his finding on the basis of the evidence.
All right. Please write down.
And my lord, this is a, as I said, my lord, this is a disciplinary proceedings. Your lordship will not go strict on the, my lord, like a criminal trial.
That is obvious. My lord, is not a beyond all reasonable doubt. I am not
Yes,
asking for that. Everybody knows that.
Please write down. Heard Mr. S. Datta, Lanet Senior Counsel, assisted by Mr. DJ Medhi for the petitioner, and also Mr. P.K. Roy, Lanet Senior Counsel, and Standing Counsel FCI, assisted by Miss
A. Chakravarti.
A. Chakrabarti for the respondents.
Paragraph 28, my lord.
I also have many, my lord, I don't want to bother your lordship with so many judgments. Scope of the court, there are numerous.
Next, by filing this writ petition, the petitioner has challenged the inquiry report dated 31/12/2023, the impugn order dated 19/9/2005. By which a penalty of reversion to the next lower post of AG1 bracket D has been imposed upon him till his retirement with immediate effect. What is this 3011? The rejection of the appeal over. 3011.
Refixation of pay.
Is it annexed anywhere?
No, my lord, it is not.
3011 is not annexed, Mr. Datta.
Just I'm saying.
refixed.
Huh? And except for pay scale. It will-
No, it is annexed, no, it is not annexed, my lord. They crave leave.
But what is the order?
It is the order by which it says petition, the para 8 says. Pay was refixed. When after the order of penalty, pay was refixed. To the lower stage.
An order dated 30/11/2005. Bracket, copy of which is not annexed. Close bracket. By which the pay of the petition has been refixed. Top next para. Facts of the case is that the petitioner, while working as assistant manager, bracket, capital D, Food Corporation of India, bracket FCI, and in charge of FSD full form,
Food storage depot.
Food Storage Depot, bracket FSD, DICOM, DIKOM, KOM, DICOM, Dibrugarh. Was issued a memorandum of charge dated 10/2/2003, white covering letter dated 25/2/2003, bracket annexure 1, requiring him to show cause within a period of 10 days of receipt of the memorandum. A written statement of defense and to state whether he desired to be heard in person. Stop. Along with the said communication, apart from the memorandum of charge framed under Rule 58 of the Food Corporation of India, bracket, staff, close bracket, regulations, 1971, open bracket, regulations of 1971, close bracket. The petitioner was given the statement of article of charge, statement of imputation of misconduct and misbehavior, with the list of witnesses for proving the charge against him. Stop. Although the petitioner submitted his written statement of defense. But the inquiry officer, upon examining two of the departmental witnesses out of the three departmental witnesses, came to the conclusion through the inquiry report dated 31/12/2003 that the charge framed against the petitioner is found to be sustainable. Stop. The petitioner was then given an opportunity to submit his representation against the inquiry report by being furnished a copy of the inquiry report. Stop. The petitioner submitted his representation against the inquiry report on 12/9/2005, denying the charges as well as the finding of the inquiry officer. Stop. The disciplinary authority, not being satisfied with his reply/representation, proceeded to issue the impugned order dated 19/9/2005 (bracket annexure Roman 4), by which the petitioner was imposed a penalty of reversion to the next lower post of AG Roman 1 (bracket capital D) and placement at the minimum basic pay in the pay scale of AG Roman 1 (bracket capital D) till retirement and with immediate effect under Regulation 56 of the Regulations of 1971. Next para, the petitioner, being aggrieved, submitted an appeal before the Managing Director, FCI, New Delhi, on 7/11/2005. But however, his appeal came to be rejected by the state authority, White Order dated 21/11/2006. Stop. Aggrieved, the petition is before this court. Next para, be it stated herein that the writ petition was filed on 10/9/2012. While the petitioner retired from service on 30/6/2012. Stop. After the filing of the writ petition, the petitioner expired on 8/10/2016. Stop. On account of his death, the wife of the petitioner, his son and two daughters have been implemented as petitioner numbers 1 bracket small Roman 1, small Roman 2, small Roman 3 and small Roman 4. By order dated 7/3/2018, passed in IAC number 637 of 2018. Top next para. Mr. S. Datta, Learned Senior Counsel, submits that since the cause of action subsists, the legal heirs of the petitioner have been implemented in his place. He submits that although the shortages alleged to have been found was written off as per the sanction made on 23/12/2001, but the respondent authorities, for reasons best known to them, proceeded to initiate departmental proceedings against the petitioner by memorandum dated 10/2/2003. He submits that out of the 3 cited departmental witnesses, only 2 of the witnesses were examined. And all that was stated by the said witnesses was that a preliminary inquiry had earlier been made in which they found some losses sustained by the FSD TCOM, and the entire report and the said report may be considered as their evidence. The inquiry officer accordingly acted upon the same by marking it as Exhibit P1. However, the inquiry report does not contain as to on what basis the findings have been arrived at by the inquiry officer. Therefore, the conclusion arrived arrived at against the petitioner is without any basis. Of the learned counsel, the learned senior counsel submits that the petitioner had clearly indicated to the respondent authorities that the decom go down was in a dilapidated condition and there were no proper fencing to prevent miscreants or outsiders to get into the campus. Stop. Such complaint and information was written to the owner of the Decom FCI Godown building as early as on 7/4/1993. And as late as 1998. He submits that apart from the petitioner being in charge of the FSD Decon, there are several other officers and staff who are responsible to look after the said FSD. But however, the respondent authorities have singled out the petitioner and fixed the liability of the loss upon him. Stop referring to the loss sustained. Referring to the alleged loss sustained, the learned senior counsel submits that the percentage of the same was as low as 1.39%. I think average, you said average 3%.
It will be 3% on average.
What did I say? Just repeat. Senior. The percentage of the same. The rest you cut. Percentage of the same, percentage of the loss in the average was about 3%. But however, the respondent authorities have stressed on the fact that the loss sustained was as high as 15%, which only is an exaggeration of the alleged loss. Stop. He submits that even at earlier point of time, the respondent authorities have decided to write off the loss sustained without drawing any departmental proceeding against those who may be responsible. But in case of the petitioner, even after it was decided to write off the loss, proceedings have been drawn against him. Now, he therefore submits that the impugn action of the respondents should be interfered with by this court. He further submits that although the original petitioner may have expired, but whatever monetary benefit that may be permissible and admissible can be given to these legal heirs who have been pleaded as petitioners subsequently. The learned senior counsel, in order to impress upon the court that in order to come to a finding against the petitioner, the inquiry officer has to come to a conclusion that the charges have been proved on the basis of admissible evidence, which is not present in the present case, by relying upon the case of Punjab National Bank and others versus Kunj Bihari Mishra Bihari Mishra, reported in 1998, 7 SCC 84. And also judgment and order dated 5/2/2025, rendered by a coordinate bench of this court in WPC number 7232 of 2015, open bracket, Nabajyoti Sharma versus the New India Assurance Company Limited and 3 others. Now, concluding his argument, the learned senior counsel also submits that Exhibit P1, a copy of which has been supplied to him today by the learned senior counsel for the respondents, also does not reveal the materials found against the petitioner by giving specific details and dates. So, in other words, only a general finding has been made, which by no means can be considered to be an evidence proving the charge made out against the petitioner. Under the circumstance, the learned senior counsel submits that the impugn orders may be interfered with and the petitioners may be granted relief, appropriate relief, as deemed fit and proper by this court. Next para, Mr. P.K. Roy, per contra, learned senior counsel, per contra, submits that the writ petition itself suffers from delay and laches. In view of the fact that the penalty, the impugned penalty was passed on 19/9/2005, whereas the petitioner has filed the writ petition only in September 2012. So moreover, the petitioner, the original petitioner had retired on 30/6/2012. Stop. It was therefore after 7 long years after his retirement. No, you cancel that. He submits that for 7 long years, while the original petitioner was in service, he did not challenge the order of penalty. And for such delay and laches on his part, the writ petition should be dismissed at the very outset. Now, on merits, the learned senior counsel submits that. No, you cancel that. On merits not required. Before that, you write again. The learned senior counsel further submits that since the original writ petitioner has expired, it was incumbent upon the successor petitioners to amend the prayer and relief being sought, which otherwise has not been done. To stop, he submits that the original petitioner is no more, and therefore there is no question of taking him back into service. Or recalling the reversion order that was imposed upon him. Stop. Therefore, without any amendment to the prayer of the made in the writ petition, court may not grant any relief to the petitioner. Stop. On merits, the learned senior counsel submits that the respondent authorities have meticulously followed the regulations of 1971 by giving due opportunity to the petitioner to show cause as to why he should not be proceeded with for having caused the loss to the FCI. Stop. The petitioner was also given the chance to participate, not only participate in the proceeding, but also to cross-examine the witness produced by the department. Stop. Upon conclusion of the inquiry, since the inquiry ended against the petitioner, he was given a copy of the inquiry report and given the opportunity to make his representation, public reply. Stop. Since the disciplinary authority was not satisfied with the reply submitted by the petitioner, which basically was of denial of the charges, the state authority proceeded to impose the impugned penalty of reversion upon the petitioner, which thereafter was also upheld by the appellate authority. To stop, he submits that when the charges have been duly proved, court may not interfere with the penalty imposed upon the delinquent officer. So in this connection, the learned senior counsel has taken the support of the apex court decision in Deputy Commissioner Kendriya Vidyalaya Sangathan and others versus J. Hussain, reported in 2013, 10 SCC 106. Did I miss out anything?
No.
Okay, one more thing before that, Mr. Datta's submission for contract ratification. Right, Mark. Mr. S. Datta. For contract, could you get it? As the Mr. S. Datta, learned senior counsel, has also submitted that even prior to the conclusion of the departmental proceedings drawn up against the petitioner, the respondent authorities have already made up their mind that the petitioner was guilty of the misconduct, which can be clearly seen from the statement of article of charge framed against him. So the same amounting to putting the cart before the horse. The impugn action of the respondents and the ultimate penalty imposed upon him should be interfered with by this court. Then the last part, last sentence coming. Oh. Okay. Okay. Learned Senior Counsel has also produced the departmental file. So I've recorded the facts.
No, sir.
This will not be CAV. With the next 2 days, you'll get the order.
No, sir.
Okay. Issue as disposed.
It's always pleasure, my lord, immense pleasure to argue with your lordship.
Deeply honest.
Yes. Who's for the other side?
I'm appearing for 2 and 3.
2 and 3.
4, 5, 3.
This was passed over for the time being last time. So why is it listed today? This is for hearing.
Lordship, he was last order, lordship may pay.
Sorry?
Details of particular payments.
Hmm.
Lordship may pay the last order. 27/3/20.
For the NRL will furnish the detailed particulars of the payments made to the writ petitioner by email by the next date of listing. These amounts are which the petitioner in person claims to be entitled to in his representation dated 6/2/2025. Addressed to the NRL authorities. So have you given that?
Details have been furnished to me yesterday, my lord. And I have.
Can you
asked-
furnish to him now?
I can furnish to him now. I think by today, the email from the office will be also be issued, my lord. Let him verify. This- Because lordship be requiring.
What are these details regarding?
These are details regarding his medical reimbursement.
Reimbursement. And anything on area salary
No,
or something like
my
that?
specific instructions are everything has been cleared, my lord. The amount of gratuity and leave encashment was pending. That also has been cleared. That is my instruction, my lord. But details I do not have right now. But I think my friend can.
What is this case actually? Removal from service?
Removal from service.
Okay. After removal from service, he has come up challenging that.
Right.
And also the non-payment of his medical reimbursement.
That is not, although that is not the subject matter, that he has subsequently alleged that it was not paid.
Okay.
Now it
The
has been paid.
Medical reimbursement.
Medical reimbursement is,
Okay.
is also given.
And insofar as the removal from service or dismissal.
Removal, madam.
Removal from service, that still remains.
That still remains.
And that is under challenge here.
That is under challenge.
Lordship, against my claim, they are still not submitting the details. Okay. I have mentioned some particular details. Against my submission, they are not submitting any.
Where's that, your claim? Where is your claim?
Lordship, in last occasion, I have already served a copy to them. Original copy I already kept it with me. Can I submit it?
Your claim?
Yes.
On medical reimbursement?
Medical reimbursement as well as salary, and medical reimbursement as salary, and they have already some amount of gratuity as well as some gratuity as well as leave encashment has been released, but they did not confirm that on the what basis they are releasing those amounts. They were supposed to give me the details so that I can defend myself, but they are not giving it. They repeatedly try to suppress the material and facts.
May I
Lordship, submit this
make a
the
submission?
copy of the document?
No, see, how long can we go on submitting papers like that, you see? The thing is that if you have a specific claim that these things have not been given to you.
Yes, Lordship.
You make
that
a
is-
claim,
Yes, that is.
you make a claim,
Yes,
and
Lordship.
accordingly we'll ask them to find out what has happened to these claims.
Yes, Lordship. That is why
Whether it's admissible or not, whether they are payable or not, that they'll find out and inform.
That is why,
That should
Lord,
be, everything should be in writing by way of an affidavit. Not that today you promise one paper and the other set gives a paper. You keep on exchanging papers. There's no end to that.
that is why I, on second, 6 February 2025, I consolidated a representation where I specifically mentioned which are the claims they are supposed to be released. Against which they are
But where's
repeating.
that? Show me, where's that representation? Is it annexed to the writ petition or
My lord,
separately?
may I make a submission? My lord? Let my learned friend filed an affidavit that these are the particular claims which he is claiming, because now the writ petition has gone beyond the main challenge, my lord. Because the challenge was his removal.
No, Lordship, in repetition also, I have submitted
Because-
there that pending disposal of this repetition can be to release the pending salary and medical benefit.
My repeated instructions is that nothing is payable at this moment, my lord.
Then why they are suppressing the issue, Lordship? If they are release those amount, they can show in the document, Lordship. Why they are suppressing the issue and facts, Lordship? They repeatedly
So what
suppress
is
and
this?
they
What is
violate
this?
by violating
This
the
is a-
order of this honorable court repeatedly.
This is a representation submitted by him, my lord, to us.
They are just
File
trying
of
to
the-
delay the process of getting justice, Lordship. They threaten me that they will harass me for a long period of time, and they also threaten me that they will manage any order and judgment of any authority. That is what they are doing by not giving me required information during the disciplinary process. They are just trying to manage the order and judgment of
All
any
right,
authority,
all
Lordship.
right. This counter allegation will go on and on. Why don't you file a precise affidavit?
That is what I
And
have already submitted, Lordship.
See, Mr. Counsel, or you are not a counsel, you are in person, isn't it? So the thing is that what you have claimed here is on the basis of some observation made by this court. Pendency is not a bar to give whatever benefit is available, which is entitled to you. So on that basis, you are saying that they have not given me, they have not given me. But there's no such kind of direction from this court that this is the amount, you give it to him. That finding is not there.
Yes,
It only says that whatever is due to them, you may give. Pendency is not a bar. So on that strength of that, you are trying to impose that they have not given me this, they have not given me that. So why not you organize your claim in a proper format and submit it? And we'll ask them to respond to that, why they have not given.
That is what I had written down over this representation. Against this representation, this honorable court specifically mentioned in the last two order, that height representation dated 6/02/2004 addressed to NIL authority.
Where is that? Which order?
Last order 27/03/2025. And prior to that 13/03/2025 also, Lordship.
The petitioner person was permitted to serve a copy of the representation file before the company. Was. If I did this, what was that? See, you do one thing, you undertake one more exercise. You file one short affidavit, consolidated affidavit indicating whatever amount you have been entitled and whatever you have been paid or whatever you have not been paid. So specifically, we'll ask them to get instruction on that and solve the issue regarding this payment of MR bill and all that. But insofar as your termination is concerned, that's another chapter altogether, isn't it? That will have to be considered. What is your main prayer in the writ petition? Let's see.
Here it starts from 255. my lord.
You have mixed up your submission and prayer and all that all together. You were serving as what? Manager
As a manager marketing.
or manager marketing?
Yes.
Yeah, under which organization?
And Numaligarh Refinery.
Numaligarh
Refinery.
Refinery.
Yes.
Okay, how long did you serve as such?
13 years.
13,
Yes.
1-3. And you were removed from service on what basis?
Actually, I applied for after a transfer order. The transfer order was violated by the respondent 6 as well as some the concerned officer which are supposed to implement this order. They themselves violate the order. Then they themselves allowed me to continue the time period that was fixed by that transfer order. After violating the transfer order, in the transfer order, it is mentioned that before releasing from my duty, I have to hand over my job to all the concerned officer, but without giving me with any instruction to hand over my job, they suddenly release me so that I cannot take leave. But because there is a rule in company conduct discipline and appellate rule in part 2 rule 27 that without prior approval. Without prior approval, no officer is allowed to take leave. So they just try to obstruct me to taking prior approval. So accordingly, there is another option to give intimation as well as taking approval in letter stage. So as per that rule, I intimated as an applied leave. Against my applied leave, they forwarded my application. They forwarded it for consideration. By duly addressing my leave, when the leave was supposed to be received by CMD of Numaligarh Refinery, that because before addressing my leave, CMD whoever either CMD authority or concerned authority has to get the required clarification whether the transfer order was violated by me or some other person. To suppress the issue, they after 112 days, they issue a showcase notice that my leave is I did not take prior permission as well as intimation. If I was not taking prior permission and intimation, then why they are waiting for 112 days? There is a conduct rule which never allowed a official to absent for leave beyond 21 days. And if official is absent beyond 21 days, it is considered as a voluntary abandon of company's asset. They themselves mention by manipulating the rule. They themselves mention in the showcase notice by mentioning that it is a very serious and grave in nature. If it is serious and grave in nature, then why they were waiting for 112 days? That is, they just issue a showcase notice to suppress their malified plan to suppress the violation of transfer order. And there are lots of issues that I will address later on.
All right. So at this stage, first thing first, if you say that you have not been paid your dues, kindly make a proper reconciliation of whatever is due according to you, and file that within a short period of time. We'll ask them to respond to that. All right. When can you file it? How soon can you file?
Till 23rd of June, I am not in the position to appear in this honorable court. Kindly fix a date after 23rd of June.
23rd of June.
After 23rd of June.
All right, no problem. We'll fix a date when you are able to appear. But you must file an affidavit, because enough of, like representations here and there, it goes here and there. If you file it in the way of an affidavit, it will remain in the record. So for future also, we can refer to that. Because loose papers will lose. We don't know where it will go, the paper will go. But so far as those documents which are filed, the pleadings which are filed, that will remain. Okay, please write. You are Mr.
Avinash Bora.
This is item number 13.
1-3.
Mr. Avinash Bora, Mr. Avinash Bora, the petitioner in person, is present before the court and submits that the amount of submits that the medical reimbursement submits that his medical reimbursement dues have not been paid till date, despite several observations and orders passed by this court. He also submits that apart from the medical reimbursement dues, there are also area salaries which are due to the petitioner. Your good name?
N Deka, my lord, for 2 and 3.
Mr. N. Deka, Learned Counsel for respondent numbers 2 and 3. On the other hand, submits that as per the instructions he has received, there are no dues which remains to be paid to the petitioner. And he submits that he has been given the details of the payment made to the petitioner by the assistant manager, HR, open bracket, benefit admin and payroll. Any submission from the other sides?
She,
Who are they?
my lord, 4, 5 and 6, my lord, he has made his disciplinary authority, appellate authority and reviewing authority party by name, my lord.
Okay,
So my learned friend appears for them.
okay. Miss D. Mohanto, Learned Counsel, appears for respondent numbers 4, 5 and 6. Anyone else? That's all.
Union of India.
Okay, your good name? Mr. ZH Bora appears on behalf of Mr. S.S. Roy, Learned CGC, who represents the respondent number 1. Stop. Although the challenge made by the petitioner is mainly against his removal from service from the post of assistant manager, marketing,
Manager marketing.
Manager.
from the post of manager, marketing, Numaligarh Refinery.
Yes.
But having regard to the claim made about the medical reimbursement dues as well as the area salaries, the petitioner is given liberty to file an additional affidavit precisely stating what according to him is due to be paid by the respondent authorities, which may include the medical reimbursement bills as well as the area salaries. Stop. Such claim should also contain the specific details as far as practicable, so that a response can be had from the respondent authorities. Stop. Let the matter be listed again on. You want a specific date?
Lordship, I will file my affidavit by 4th week of June. Kindly, if possible, kindly fix a date for the respondent so that they can file the reply before listing the next date, Lordship. Then otherwise, the matter was last years I have been suffering, Lordship.
When can you file? You tell me.
I'll file by 4th week of June, Lordship.
Okay. So we'll list it in July then.
My lord.
Oh no, after summer holidays
Yes, my lord.
on 17th.
17th.
Release the matter again on 17th of July 2024-25 as paid for. Stop. The petitioner shall file the additional affidavit as directed by furnishing a copy of the same to the Learned Counsel appearing for the respondents on or before
Lordship, 27th of June, Lordship.
27th of June 2025.
My lord, if he submits, if he is insisting that we should file our reply before the next date of listing, my lord, 17th may not be possible for me to respond.
Lordship, it is not a new issue, Lordship. It's been, Lordship, last 3 years, they are already gone through all those documents. They already submitted a reply that I
No,
have.
then in that case, why don't you,
They are taking so much time, Lordship, that.
no, in that case, why don't you file before this 27th? Can you file before that?
Lordship, till 23rd, I'll be busy some other issue, Lordship, because.
Okay, then we'll have to extend the time. Because on reopening immediately may not be possible.
May not be possible.
Because 27, you'll give a copy, then for them to take instructions and reply, they'll need some more time. We'll make it 29th
Hello.
of July. List the matter on 29th July. Okay, instead of that.
Lordship, kindly fix a date that within by which date they will going to reply. Because before the date, if I get the reply, then I will submit my.
What is the
reply.
last part?
By 27, I am going to reply.
Okay. So thereafter, the respondents
I'll file it by 24th, my lord.
shall file a response to the same on or before 24th of July 2025, so that the matter can be considered. What was the date I gave?
29th.
On 29th of July.
Obliged.
All right.
I didn't forget.
Yes.
In this case, my lord, I am led by senior advocate Ken Chaudhary, my lord. He has left the court today for he is going to Delhi, my lord. And
When?
first half, yes, he was there.
When?
My lord, I pray for a date, my lord, in the first week of June, my lord. On 2nd of June.
What is the matter regarding?
A matter, my lord, is the second round of litigation, my lord. The participant, my lord, the petitioner was appointed as the SES cadre.
Promotion?
No.
Seniority promotion
No, no,
or
no,
dismissal?
Not dismissal, neither dismissal nor promotion, my lord. He was, he is serving as a SES cadre. He has not been paid one MSCPS benefit, my lord. MSCPS.
Or claim for MSCPS?
MSCPS,
Okay.
MSCPS.
All right.
That is the thing, my lord.
All right. As paid for by Mr. B. Prokashta, learned counsel for the petitioner, who list this matter on 2nd of June.
I am for 1 and 2, my lord. Respondent number 1 and 2.
Mr.
DC Sutia, my lord. Additional senior governor.
DC. Mr. DC Sutia, learned additional senior government advocate appears for respondent numbers 1 and 2. Yes.
Obliged.
Yeah, please, Lordship.
Yes.
Lordship, petitioner is a permanent employee of respondent number 1, and respondent number 1 is a cooperative society. It was running a spinning mill unit, your lordship, but it closed down in 2016.
Running what?
Respondent number 1 is a cooperative society.
Cooperative society.
And it is running a spinning mill unit.
Spinning mill.
Clothes, manufacturing of clothes, lordship. And the petitioner was working as a accounts officer therein, and he worked for approximately 10 years. And unfortunately, the mill closed down in 2016, your lordship. And after that, the VRS policy was rolled out by the Department of Public Enterprise, your lordship. But the petitioner name was not included in the said VRS. And thereafter, the petitioner submitted a representation before the Registrar of Corporate Society, your lordship, that is in annexure number 8. And even after submission of the representation, lordship, there was no reply. And being agreed with lordship, the petitioner has filed this writ petition. And thereafter, the respondent number 5, your lordship, that the registrar has submitted a affidavit in opposition, countering the point that the petitioner is not entitled for VRS because he has not performed his duty. And the respondent's stand is that after the closure of the mill, the petitioner's service was required because of working as an accounts officer, and he was supposed to close the accounts for 2016 and 17. And as he did not do that duty, some problem was faced by the respondent. As such, they have decided to debar the name of the petitioner from the list of VRS. But the petitioner and interesting, your lordship, the petitioner was never informed of the decision. Only when after this petition was filed, it has come to knowledge of the petitioner that his name has not been included. He has submitted representation, there was no reply. No disciplinary proceeding was initiated against him. He was neither suspended nor dismissed from service. Even on today's date, he is still an employee of your lordship. So,
Even today, he is still an employee.
Yes, because we there is nothing on a record to show that he has been dismissed or he has been suspended also, your lordship.
But is he working?
But the mill has closed down, your lordship. Nobody is
closed
working.
down, nobody works.
Nobody is working there. And interestingly, all the other employees have been given the benefit of the VRS. They have actually been considered because another case is going on right now, your lordship. And your lordship has passed the order on 1st of April, your lordship. In that, the case number is, your lordship.
That's lordship WPC 2297. In that case, I have appeared, your lordship, and the part payment has been made by the government, your lordship.
It's a last.
As a VRS dues.
2297.
Yes.
2297, lordship. An order was
Of
passed.
which year?
2019.
2019, your lordship.
Okay.
And
So petitioner cannot be a beneficiary under that?
Lordship, the stand which has been taken actually, the petitioner, he's an employee under the mill, your lordship, and and that's a cooperative society, your lordship. And he have been appointed by the board of directors, your lordship. He's not directly comes under the cooperation department, your lordship. And whatever stand has been taken is that the board has taken a resolution not to give him the benefit of VRS, your lordship, because he has been found absent from his duties, your lordship.
But no display action was initiated, lordship. That is our main contention.
But what is that? What is the order impugned then? By which?
Order impugned, lordship, is that we have submitted the representation and no reply was given to representation and.
No, not the representation. You were saying that he was found not to be
Lordship,
attending his
notice
duties.
has been issued to him, your lordship.
Where is that finding? That he has not been attending his duties, so.
Lordship may take up the affidavit in opposition, lordship.
By file by? R5.
Respondent number 5, your lordship.
Who's R5?
Respondent number 5, your lordship, I represent the register of the cooperative society.
You are there for R5.
Annexure to page 45, your lordship, of my affidavit in opposition. This is a show cause notice issued on 26/7/2019, your lordship. If may I read it, your lordship.
So, what is your reply to this?
So, your lordship, we have taken a stand. We have not received the so post notice, your lordship, and there was no tracking delivery report has been annexed, which shows that they are saying that we have refused to accept, your lordship, but no tracking has been annexed showing that we have either it has been delivered or we have refused to accept. So we have never received any so post notice, your lordship, and even prior to the issuance of this so post notice, the respondents had already decided that they will not release the salary of the petitioner. So, lordship may come to page number 49, your lordship, of the affidavit of petition. That is the minutes of discussion held on 23rd September 2018 at Apple Mill premises at 10:30 AM. And therein on page number 49A, lordship, next page is saying, salary of MD Abdul Taleb, account officer who worked at head office, will be kept under hold as he is not keen to extend help to the mill authority and has not come forward to complete the annual accounting job for the period FY 16-17, FY 17-18, in spite of several telephonic requests as well as wide letter dated 15/18 from the mill authority.
it may be mentioned that Mr. Mohammed Talib is conversant with account keeping of the mill as he was maintaining the records related to account. So even prior to this was on Lordship 23rd of September 2018, and so cause notice was only issued on Lordship 26/7/2019. So they have taken already a punitive action again, even without informing the petitioner, your Lordship. So that is itself is like directly against the principle of natural justice, your Lordship, and totally violative Article 14. And there have been several judgments which say that before taking any punitive action, the petitioner should be given a chance of defending his Lordship. And there are various other anomalies also, your Lordship.
Lordship. Lordship, in that case, your Lordship, the shortlisted numbers of employees, 394. Their VRS dues has been calculated by a chartered accountant firm, and it has been placed before the government. And the total dues as on date was 30 CR, and out of which 12 crores has already been paid. Now remaining 18 crores will be paid within this financial year. That submission I have made it on the last occasion when the particular matter was listed. Otherwise, this matter doesn't have any connection with that. If the petitioner is entitled, then his name has to be included among 394. The 394 employees, 395 will be the petitioner. If he succeeds in this particular matter, your Lordship.
Lordship, I only submitted very small window frame of time because that this amount as per the last order has already been sanctioned, your Lordship. So if once the amount is disbursed, that this repetition will become kind of infructuous, your Lordship, because this amount has
No, that amount which has to be sanctioned is calculated for a specific number of employees, isn't it?
Yes, sir. So
if one or two is added more, then they'll have
recalculations will
the
be required.
figures will be recalculated.
Yes,
Will have to be
sir.
recalculated.
Yes.
So this is the
That
thing.
is true, your Lordship, but there is no difference between my standing, difference between the petitioner and the other employees.
But how do you say that because of your case not being calculated in that thing, this will become infructuous? How can it be?
That is
That'll be decided. It's as per its own time.
agreed, your Lordship. That is the but because it's a very time consuming thing of again getting the approval, Lordship, that is my humble submission to fix a small.
So that approval given is for a specific, for a number of
Numbers of
persons.
employees, your Lordship.
It's not that it's a large amount, anybody can come in and join. It's not like that. Based on the calculation, some approval has been sought for. If you succeed in this case, then definitely something else some more calculation will have to be done.
Yes, sir.
So, well,
And also, your Lordship, only this person, this petitioner has only been singled out. All the other employees, they have not reported to duty. And he was also reporting duty even after 6 months after closure to mill. But after that, he was not being paid salary, and the office got shifted from Guwahati to Dongia, which is like around 60 to 70 kilometers from Guwahati. So he submitted that he didn't have the money to travel every day. So that was the reason he could not perform duty after 6 months after closure of the mill. And nowhere in the VRS policy it is mentioned that you have to keep performing the reporting to office. Only then you will be eligible for VRS.
okay, when do we have this matter? Johnny.
Lordship, anytime this next week also is fine, if that is possible, Lordship, or week after that. A date may be fixed, Lordship.
We have fixed so many matters, I think.
First week of June.
Week after.
First week of
We'll have it in the second week of June.
Lordship.
10th of June.
Lordship.
It may be kept as part of your lordship.
As paid for, this is the matter on 10th of June.
Because lordship is in a very precarious position, lordship, because he is not received this amount.
10th of June, okay? Not part.
Public.
In my lord, we both are agree any other day, today time it is. Otherwise, it will take some length of hearing also.
Lodge,
10th of June,
my lord.
as paid for by the parties, this is the matter on 10th of June.
Obligors.
Oblige.
May I please, your lordship?
Yes,
My lord, the petitioner before your lordship is the RPF constable, my lord.
sorry,
RPF constable.
is it a short matter?
To remove it
Yes,
from
madam.
service.
It'll take some time. Do you have the records with you? Records will be required?
My lord, my prayer is very limited, my lord.
Limited what? You want to go back to service?
Not,
You
Yes, my
you want reinstatement?
yes, my lord.
So something
And-
wrong with
and-
something wrong with the entire inquiry.
Yes.
So I think we should have the records so that we can rely upon that also. You produce the records. How long should you take to get the records?
Let it come up after 4 weeks, lordship. Otherwise, my affidavit is there, lordship.
Okay,
My lord, a date
he's
will be
right. Parties
fixed.
are represented by the respective councils. Challenge made in the standard petition is with regard to the penalty of removal from service after the panel proceedings drawn against the petitioner. Stop. Considering the challenge made, perusal of the departmental records would be required. Ms. B. Sharma, Lanet, you are CGC, shall produce the records by the next date. List the matter. You want 4 weeks' time,
Before vacation.
19th of June.
19th of June.